Hi, you guys. How is everybody? Everybody say hello as you're coming on in. We have a bunch of responses from the state. We also have a new filing from Doug Weinstein. And we're also going to revisit one short thing from June 10th, because the June 10th thing is the thing that the state seems to have filed like 4 motions responding to on the 26th. I think they maybe should have responded to that on Tuesday, but who's surprised? So to start, we're going to see what this June 6th thing is. It's really short. You may remember it. It was originally filed by Brian Steele, and ThuggerDaily had originally shared it. That's also where these documents are coming from today. So if you want to show ThuggerDaily some love, his CashApp is BennJesus with 2 N's. There it is in the chat for you guys. But this June 10th thing from Brian Steele was a motion asking Judge Glanville, hey, look, the state keeps trying to make objections. They're not really proper. Can you revisit that? Can you make a new ruling? And can you also reconsider some of the other rulings you've made on the evidence? All these open standing things. So you might remember this, but the prosecution has made objections on countless occasions based upon OCGA 24-8-801C on the grounds that they were self-serving statements of a party. This honorable court has, in almost all instances, sustained the objection. This objection and the ruling are not well-founded. Mr. Williams has offered into evidence on many occasions supposed utterances of Mr. Williams, not self-serving statements, but in oftentimes lyrics, that this court has denied admission into evidence based upon the prosecution's potentially specious objection to self-serving statements. So, we want parts of lyrics to come in, but not the whole thing, because the whole thing would make it look different, and that's self-serving. That's kind of my summarization of what Love argued when she wanted to cherry pick certain lyrics and was trying to oppose Brian Steele's argument that if they're going to come in, they should come in as a whole. So this was the written motion because this was still an issue on June 10th. If you've been watching this trial from the beginning, you know June 10th was not the first time that this was an issue. So he goes on, all of these issues are preserved for appeal. And then moreover, down here in paragraph 5, lyrics or social media postings should not be barred by any hearsay objection because they become relevant based upon the prosecution's presentation of evidence under the rule of completeness, and oftentimes are not admitted for the truth of the matter asserted, but for the effect on the listener or to put conversations or issues into context. However, this court, for the most part, has prevented Mr. Williams from receiving a fair trial by this court sustaining possible meritless objections by the prosecution. It's interesting to note that there is no hearsay provision in our new evidence code that even uses the term self-serving statement. And the citation here was, see the entire OCGA. Again, this is Brian Steele writing. Courts from across our country who use federal rules of evidence have all come to the conclusion, as opposed to the state's continuous self-serving objections, and this court sustaining the same, a quote flat rule against self-serving statements makes no sense. See, for example, from almost 40 years ago, United States v. Jackson. This prosecution should not be allowed to continue to stop Mr. Williams from presenting the truth in this case through competent, admissible means based upon specious objections. So, the last argument that was made in this June 10th thing, that we're going to get like 4 responses to from the state today on July 26th, was that while discussing specious prosecution objections, these objections to vague, when there's nothing vague about the question posed on cross-examination, the objection to, quote, facts not in evidence, need not be sustained any further. It is abusive to the Sixth Amendment to sustain these objections as lawyers for the criminally accused. They have the right to cross-examine, and to cross-examine, oh, this is really tiny. Let me make this one bigger. But to cross-examine effectively, thoroughly and siftingly, and asking the leading question, which introduces facts, is not objectionable. These questions are not evidence, therefore the question does not interject facts not in evidence, but the question combined with the answer becomes evidence. Thus, on a multitude of countless occasions, cross-examiners have been totally barred. So we're only in the state's case in chief. So the term cross-examiners right now in this context means defense counsel, because the state hasn't done any cross-examination yet. So these cross-examiners have been totally barred from presenting competent, truthful evidence from the jury based upon this wall of specious objections that are being sustained. This must end as well. So they make this argument. And now, today, Guys, we've got 4 individual response. Like, let me just show you how I have it laid out in my little document here. So again, ThuggerDaily provided all these links, but one of them is addressing the facts not in evidence definition, then the adoptive admissions, then the self-serving hearsay, then the vague objections, and they're all 5 to 8 pages long. So the state is making 4 responses to this June 10th thing today. Let's see what they say. And I'm sure nobody's surprised. So you can see that this was filed today at 10:13 a.m. It's the state's response in opposition to defendant's motion for correct ruling on assuming facts not in evidence. This is one of those things. On June 10th, Williams moved this court to vacate proper rulings on state objections precluding cross-examination questions which assume facts not in evidence. And this might just be a citation. Oh, and then we get July 10th, Williams filed an amended motion. So the defendant Williams' motion addresses multiple separate evidentiary rulings. This motion addresses paragraphs 10. And again, we're going to get these separate motions from the state, these responses, to break it apart. Defendant Williams does not include a request for a specific relief or provide authority to substantiate his request. Instead, Williams cryptically asserts that somehow his right to effective cross-examination has been curtailed. Trial court correctly, actually they did assert that it was all of the cross-examiners. Trial court correctly sustained state's objections to questions assuming facts not in evidence. Williams' motions should be denied. So the argumentation and the authority. At the outset, Williams never provides authority that inquiring into unproven and irrelevant areas, to wit, facts not in evidence, classifies as a specific mode of cross-examination imparted by constitutional requirement. So they cite here Johnson v. State with the quote, "Unlike many other modes of impeachment, attacks on witness bias are constitutionally guaranteed. Even grounds that are constitutionally protected, however, may be subject to judicial controls." And here they're going to cite Lucas v. State, where it says the right to inquire into partiality and bias, however, is not without limits. And let's make sure this footnote, they put other supporting case law here. So Carlson versus Carlson and Carlson again. The Fifth Circuit has made it clear that questions which assume facts not in evidence are not constitutionally protected and subject to exclusion by trial courts pursuant to the rules of evidence. So here they're citing Rule of Evidence 611, Federal Rule. Oh, what am I clicking here? We're not trying to go to LexisNexis. But that is nice that they actually are linking, because some of their other responses, they weren't even giving their citations, right? But now they're giving citations and they're making it easier to get to. So shout out to the state on that improvement. The court should exercise reasonable control over the mode and order of examining witnesses and presenting evidence, so as to 1, make those procedures effective for determining the truth, 2, avoiding wasting time, and 3, protect witnesses from harassment or undue embarrassment. And we get some bolding. The rule permits courts to preclude questions that obscure truth because they're ambiguous, confusing, misleading, argumentative, compound, or assume facts not in evidence. Williams' motion attempts to constitutionalize areas of cross-examination that is not so protected. Even assuming arguendo that questions assuming facts not in evidence were of the same stripe as an area like bias in Rules 401, 403, and 611A would preclude Williams' proposed inquiries. So they're saying even if you don't agree with this, what the federal rule says, we've got all these other ones that should hold up. Williams' Sixth Amendment right to effective cross-examination was not infringed by disallowing questions seeking to elicit facts not in evidence. Pursuant to both OCGA 24.1.103C and 24.6.611, the trial court has correctly prohibited defendant Williams from posing questions that assume facts not in evidence. So here we have OCGA 24.1.103C holds that jury proceedings should be conducted to the extent practicable, so as to prevent inadmissible evidence from being suggested to the jury by any means, including but not limited to making statements or offers of proof of asking questions in the hearing of the jury. Courts are mandated, and we've got a footnote, and they're just giving us a citation to the same OCGA. Actually, no, it was different. So the court shall exercise reasonable control. So it's not a may, it's that they should. The courts are mandated per OCGA 24-6-611 to exercise reasonable control over the mode and order of interrogating witnesses and the presenting of evidence. Now, I would like to know how far apart these two sentences are. Because why are we making a footnote to add this quote in? And then up here, we're giving a different quote. So maybe this isn't, maybe a shall doesn't precede this sentence. Maybe there is discretion here. And we're leaving a footnote that makes it seem there is no discretion. So I have questions. So we don't know if there's discretion here, but in order to make the interrogation and presentation effective for the ascertainment of truth, we get another footnote. So it's saying the same thing, also citing to this. So it looks like we're doing that thing where we put a bunch of quotes together, and I don't know if we can always rely that they're coherently placed together, or if there's missing parts that would be important. Reading these statutes in conjunction with one another, courts are authorized to prevent counsel from asking questions in the hearing of the jury that are premised on inadmissible evidence to facilitate ascertainment of the truth. Defendant Williams asserts that the court's sustainment of objections for questions that assume facts not in evidence curtails the Sixth Amendment constitutional rights, but cites no legal authority for that proposition. And I think they're just referencing the same thing, so the motion, paragraph 10. Now, do we have paragraph 10 in those photos? Let me go back to ThuggerDaily's thing. Or actually, after this, while we get some chat going, I can go and look for the July 10th amendment to that motion. We can see. We can go and see. Because here, we're going down to paragraph 10. This is Brian Steele's, what we have from June 10th. Furthermore, while discussing specious prosecution objections, these objections to vague, when there is nothing vague about the question posed on cross-examination, the objection to facts not in evidence need not be sustained any further. It is abusive to the Sixth Amendment. So, the grounds would be Sixth Amendment, but are there interpretations in any cases that have backed this up? Maybe that's what Love is looking for. So, we'll have to see there. We were back over here. We're going back over to the state's motion. So here, Love is going to say that case law explains that the Sixth Amendment provides two types of protections for a criminal defendant: the right physically to face those who testify against him, and the right to conduct cross-examination. And they cite State v. Burns. However, the Confrontation Clause guarantees an opportunity for effective cross-examination, not cross-examination that is effective in whatever way and to whatever extent the defendant might wish. So, and this emphasis was in the original, and that's actually important to note. Furthermore, trial judges retain wide latitude to impose reasonable limits on cross-examination based on concerns about, among other things, confusion of the issues or interrogation that is repetitive or only marginally relevant. And we have Picklesimmer v. State. All defendants have been afforded and will continue to be afforded the opportunity to confront and cross-examine witnesses the state calls in this trial. The state will not object to cross-examination that is legally sanctioned. Williams' right to cross-examination is not abridged where the examination is limited by the trial court to relevant matters by proper questioning. Now, it is probably worth noting, trial courts, the judge, they do have a wide range of discretion. But there can be an issue when that discretion, if this is a spectrum, and this is the middle, right? Here's the defense, here's the state, opposing parties. And the judicial discretion tends to significantly lean this way consistently. That's where it could become a problem. That could be an appeal issue. You know, disliking one decision that a judge made that falls within the proper range of discretion, an appeals court isn't going to be like, oh my God, that's horrible. Take it back down to the trial court, retry. But when there is a pattern where many, many, many rulings tilt in one direction or another, then an appeals court could find that, that's an error and it could have caused some harm. They could also find that it was an error, but it didn't cause any harm, So to me, this is really kind of a non-issue if we're looking at mistrial motions. If Judge Whittaker is considering a mistrial with prejudice, this stuff wouldn't really even apply. This stuff would be something that, case moving forward, let's get better rulings and have a fair trial. And Love is saying, it is fair already. We don't need to change anything. Those rulings were good. They were sound, they were consistent, they were proper. And then I do want to stop. Thank you so much. I see Taviz TV with the $20, a little lunch money. Might be dinner by the time we get through these. But thank you so much. That's awesome. And let me know, put it in the chat if you are going to go live and talk about these too, because you've been covering all this stuff also. And then EDW Raptor giving out presents. Happy Friday, you guys. Everybody shout out EDW Raptor. Put a little dinosaur emoji in the chat. I love dinosaurs, you guys. One of my favorite video games is this game called Ark. You can pick a dinosaur, or you can tame dinosaurs. You can have a little tribe with all these different dinosaurs. It kind of sucks because they can die and stuff. So you could get attached to your little character dinosaur and then they get mauled by something. But really cool game, really fun game. So thank you both to Taviz TV and to EDW Raptor. And then where was I? I think I was down here in argument B. So objections to assuming facts not in evidence are proper. So we just gave you our arguments, what the case law says, and now we're going to say that our types of objections fit within that, so they're not improper. Permitting questions that assume facts not in evidence to a witness can confuse the jury because they are considered information that is never properly admitted as evidence in trial. And guys, this is going to drive me nuts. If you were with us last Friday, I did that stream before the status hearing with Judge Whittaker happened. And what did we rewatch? What did we talk about? We did talk about Adrienne Love and possibly inserting herself as an unsworn witness, which means she's not a witness, but through her questioning, she's putting into the record facts not in evidence. And Brian Steele has previously called for a mistrial on this ground. That was when she was questioning Miss Bennett on the stand. So it's really interesting in that context to read this. Permitting questions that assume facts not in evidence to a witness can confuse the jury because they are considering information that is never properly admitted as evidence in trial. You did that, Love. You did that. In United States v. Almanzar, the court overturned a trial judge's decision to set aside a jury verdict based on insufficiency of the evidence because the district court assumed facts not in evidence and made unsupported assumptions. Defendant Williams' improper questions, which assume facts not in evidence, could confuse the jury during deliberations, similar to the trial judge in Almanzar. In Satterfield v. State, appellant enumerated as error at trial counsel's failure to object to the prosecutor's questions of a witness, which improperly assumed that these defendants had created the mess, a fact that the witness did not know and which was not directly in evidence. And then let's make sure this footnote, so they're just giving the state there. Ultimately, the court held the trial counsel's failure to object to these improper questions could be qualified as a reasonable strategic decision and did not find prejudicial error. Nonetheless, the fact that the Supreme Court diligently undertook analyzing appellant's objection to improper questions that assume facts not in evidence underscores the validity of such an objection. I would say in that context, maybe, but when you see language like they looked at the objection, which means they did make considerations about the objection. But they're talking about whether or not that was strategic on trial counsel's part, the attorney's part. It seems like their decision was less aimed at this reasoning, but Love wants to apply this reasoning for sure, 100%, to interpret the case law to mean this. So I would actually like to see this argued. This is where you get really nuanced and, attorneys will go back and forth. The judge might have questions of their own. Glanville, we don't have to guess which way Judge Glanville would lean, but we don't know how Judge Whittaker would want to read into the fine lines between case law that's being cited. So if this is argued next Tuesday, let's pay attention to Satterfield v. State. If we see any interpretations going back and forth across the floor and what the judge says about that. Satterfield v. State. Defendant Williams classifies such objections as specious, but the Supreme Court of Georgia and federal courts view them as unequivocally valid. Moreover, Williams seeks to ask questions that imply matters that, at best, Williams cannot substantiate. For example, Defendant Williams asked Detective Belknap, "Do you realize that in Fulton County and in our county, the only artist lyrics that have ever been prosecuted in a criminal case are rap lyrics?" And that's a footnote here to a YouTube link. So, I mean, it's only 7 seconds, so I'm assuming it'll be exactly that, or 11 seconds. To begin with, this question is predicated on a falsehood. As this court's detailed order on the introduction of gang lyrics proves, this is not a true threat case, and not one defendant is being prosecuted for expressive activity of any kind. Plus, this line of questioning is unsourced and in conflict with known proof. No evidence had been introduced regarding national prosecution statistics on defendants' lyrics in criminal trials. So, what are we getting here? We had 2 footnotes in that sentence. So the first was Chief Judge Glanville's order granting admission of evidence of lyrics at the trial from November 27th of 23. The court found no defendant in the in-state case is being prosecuted for a charge involving a true threat or any exercise of any right protected by the First Amendment. Furthermore, this court finds that in neither briefing nor argument did any defendant demonstrate to the contrary. It should be noted that no defendant or group on their behalf filed any motions challenging the legal analysis in this court's order on the admissibility of the gang lyric evidence, much less sought a certificate of immediate review related to same. In fact, as the state's... I like how footnote 3 continues as if it's reading right from footnote 12. In fact, as the state's written brief on the admission of gang lyrics demonstrates, those statistics show low numbers of introduction of lyric evidence in gang prosecutions when arrayed against the size, scope, and volume of gang crime. And they cite the state's second supplemental motion in limine, which was actually submitted in a timely fashion and not in the middle of the trial. So where were we? We were down here. Similarly, Defendant Williams' counsel asked Special Agent Rassi if he knew that Dolly, Defendant Williams' sister, was in a relationship with Jimmy Winfrey in 2015. State objected because there had been no evidence that the two of them were in their relationship in 2015. And then Williams does not have a right to float unsupported and unsupported distractions, using sworn witnesses as the vehicle. What are we not supposed to do with sworn witnesses? Don't use sworn witnesses as a vehicle for things that you want to get on the record. I would be so... That's a little bit audacious to make one of the fixtures of your argument here about the defense doing something they shouldn't be doing with a sworn witness. Oh my goodness. Therefore, Williams requests to prohibit this court from sustaining any further objections to questions that assume facts not in evidence should be rejected. And we've got 2 footnotes on the signature page, which is tacky. Defendant Williams' motion at paragraph 10. Should Williams believe that this is evidence that is admissible, he has also failed to make an offer of proof pertaining to these matters as required by law. So, boom. That's the end of this. What do they want? We disagree. Basically, Williams' assertion that his Sixth Amendment rights have been curtailed by the court's sustainment of state's objections to questions that assume facts not in evidence is invalid and unsustainable. There is no constitutional or statutory right to ask irrelevant and unsupported questions during cross-examination. The prior evidentiary rulings on this matter have been in accord with the Georgia and federal constitutions and rules of evidence. There we go. And again, it's just Adrienne Love signing these. Yeah, and I swore she mentioned an exhibit, but it's not attached here, so who knows. So there's that. That was all about paragraph 10 of this thing from June 10th that was amended on July 10th. It was all about this paragraph, the bottom half and this big paragraph at the top. That's what we're looking at. We've got 3 more motions about other things in the same initial 4-page filing from the defense. I can't believe they put the sworn witness. They're using sworn witnesses. They're using them as a vehicle to get what they want into the record. What have we had this month-and-a-half long pause for? Why have we been on this pause? Why do we have a new judge? Why do we have all these things? Because we tried to use Lil Woody as a vehicle to get in all these videos of him saying things that he says were lies back when he said them. Adrienne Love. To be fair, it's her job to try, and it's her job to make counter arguments. So, the next one we got deals with adoptive admissions. And what are you guys saying? Let's get some scrolling and random comments. We're going to start with the what, why, and who's. Good to see you. So, I wake at 2 a.m. just to watch you live. Oh my god, that's the time zone for that's like 11, maybe 10 hours off, depending on when you sent this. So geez, that's so crazy to think about. I always think about visiting like Australia, and then I don't know if I could deal with that plane ride. But you think I'm clever and sweet. That's so sweet. I appreciate you. I see a bunch of dinosaurs. I appreciate that, you guys. And then Taybiz TV gave us an update saying that he will be covering the Boozy re-indictment, but may do a video instead. So I think I've seen Drea drop Taybiz's channel link in the chat. Great content, really good voice, easy to listen to if you guys like that. So if you're interested in that Boozy indictment, hop on over there. And that's crazy. I think Boozy's in my neck of the woods often too. Like he goes between Atlanta and Florida. He's down here. Like I see him in Snapchats with like friends sometimes. And the palm trees are in the background. So I'm assuming they're here. But I heard basically he's getting re-indicted on the thing he just got off for. So that sucks. There you go. Look, Floridian here. Sentinel is from Orlando. We got all the way in Ireland. Can't wait for Tuesday. Yeah, it's going to be... I think it's going to take more than one day, even with Whitaker holding down the clock. I think there are a lot of issues, even if she keeps it chop, chop, chop. I think we might have more than one day of oral arguments. What are you guys thinking? Yeah, I love footnotes. I love arguments and footnotes. Sassy footnotes. I think, you know what? I would hope that they're still working because they were put in... This is the other motion. Let's go back to this one. I'm sure this was recently drafted. Because she only has to make this argument because it's a new judge that said, look, we're going to deal with these things that have been left open. Yeah, so that link worked. And it wasn't a timestamped link, but whatever. At least it's a working link to a video. But that is true, Ghost. That's a good point, you know, and the defense has done it too. They've cited 2 YouTube videos, and if that video gets taken down or privated, you know, there needs to be a file somewhere that's accessible. And then heck yeah, shout out to ThuggerDaily. And then Tasker66. I'm thinking more and more that the DA wants a mistrial without prejudice. Run it back, give us a second bite at the apple, allow us to do that. Because we could tighten up our many loose ends. Maybe do this better the next time. Because I do think that the state would have a better chance if they got to start from zero than if this trial moved forward with what has happened so far. Even though the jury hasn't really been in the courtroom for a month and a half to see the stuff that we've been really focusing on. I think going through about 80-something days and still not knowing what certain defendants may have even been a part of. It's not really a good thing to drag the jury's attention span out like that. So starting over, cleaning it up with a judge that's efficient, could keep the jury's attention better. They could tighten things up. They could make a more convincing case. I think I'm right with you. I'm right with you. I think my gamer tag... I'll put it in the chat. It might not be it. There might be a number to it. But that's been my gamer tag for years. If there is a number, it's probably 99. And then thank you so much to Ghost and Drea for dropping document links too. Let's get back into these motions. You guys keep the convo going over there in the chat. I know you'll hold it down. So again, this one that we're going to look at, which one are we on? Am I on the wrong one? We want to look at adoptive admissions. And I honestly wonder if these motions are going to kind of, maybe the case law they cite will be different. But I wonder if they're going to kind of repeat themselves, if they're going to cite back to this one thing from the defense. So let's find out. And again, this was filed today, this morning. State's response in opposition to defendant's motion for correct ruling on adoptive admissions. Despite binding Georgia, so binding means it's like close, it's parallel, it's right here, it's not from a court from somewhere else. It's something that's actually been adjudicated right here in our own neck of the woods from a court that's above this trial court. Despite binding Georgia and persuasive federal precedent authorizing their admission on July 10th, 2024, Defendant Williams moved this court to vacate correct prior rulings on the introduction of adoptive admissions under OCGA 24.8.801 2B, Rule 801 D2B. And we have a footnote. Defendant Williams' motion addresses multiple separate evidentiary rulings. So this time we're looking at paragraph 11 regarding adoptive admissions. Defendant Williams does not request specific relief on this matter, nor does Williams delineate why this court should eschew binding and persuasive statutory and case law. Nonetheless, the trial court has correctly ruled on adoptive admissions in this trial in accord with the Georgia Federal Rules of Evidence. Williams' motion should be denied. But I do want to say, this is the second time that she's opened in the paragraph taking issue, I'll make this bigger, taking issue with the state not requesting something, but they requested a hearing. We want the above requested relief. So some of the requests were stop sustaining all of these objections. So I don't really get why, did they want something more specific than that? Because at the very least, they wanted a hearing. But secondly, all throughout this, they said, can you stop sustaining this so much? Stop letting this happen. So I'm not sure why we're getting openings in these two responses from the state so far saying they didn't ask for anything, because they did. Argument and citation of authority. Sending Georgia's former ban on their introduction to oblivion. The Supreme Court of Georgia, in accord with federal precedent, approved the introduction of adoptive admission in criminal cases in State v. Orr. And they're also giving other supporting cases. We saw the same citations in the first argument. In the state's briefing argument and this court's order on the introduction of gang lyric evidence, the concept and application of adoptive admission were delineated in considerable detail. And we've got a Chief Judge Glanville order. This seems like the same that we just read. Are they just copying and pasting the issue? Right? I am on the correct one, right? Adoptive admissions. We might be plugging and playing on these 4 different issues here. The state incorporates that material by reference and provides the following in summary and supplemental response. So Rule 801 D2B authorizes the previous court's rulings on the introduction of adoptive admissions and governs a trial court's consideration of the same. Rule 801 states, admissions shall not be excluded by the hearsay rule. An admission is a statement offered against a party, so party opponent, it's against the opposing party, is a statement of which the party has manifested an adoption or belief in its truth. Defendant Williams is partially correct in asserting that mere silence by a party opponent in the presence of another statement, standing alone, does not automatically equate to an adoptive admission. However, a defendant's silence may, in certain circumstances, communicate that he has adopted another person's statement as a true, make that statement admissible under Rule 801. So we've heard, I believe Max Shart has talked about this too, but we've heard that emphasis like, we're objecting just so you can't say that we didn't object and that by not objecting, we adopted what just happened. So Steele isn't the only one that's had an issue with this. They've been aware that because silence could be interpreted a certain way, we're going to make the objection, because if we don't do it, we could lose later. In evaluating whether we had a footnote. So they cite Wilkins v. State for that. In evaluating whether evidence qualifies as a defendant's adoptive admission under Rule 801, the trial court must find that 2 criteria are met. The statement was such that, under the circumstances, an innocent defendant would normally be inducted to response. And 2, there are sufficient foundational facts from which the jury could infer that the defendant heard, understood, and acquiesced in the statement. After this initial determination is made by the trial court, the jury is then responsible for making the ultimate determination of whether the defendant adopted the statement as true. A clear example is found in Wilkins, where the court found it was reasonable that a statement referring to a bloody t-shirt in the trunk of the car that appellant drove up in and was standing next to the shirt as "we used to wipe blood and fingerprints off a gun" is the kind of statement that would normally prompt an innocent person to clarify. Clarity? I think that's supposed to be clarify. To clarify that the was not part of the we. I think this is supposed to read, okay, so it looks like the case law has it wrong. They say quotation in original. But I think the interpretation is, if someone's testifying on the stand, we, meaning me and one of the defendants out there, use the t-shirt to wipe fingerprints off the gun. In other words, we were hiding evidence. We were trying to take our fingerprints off. And the defense counsel doesn't object to the we. They're then adopting that statement. They're letting it stand that we, including my client, the defendant, wiped the fingerprints off this gun with this t-shirt. So this looks like there were some typos in the decision. The foregoing said, a direct confrontation with the accusatory statement is not always coupled with lack of denial required for the application of Rule 801. See, for example, the cases provided below. So in United States v. Hankton, the trial court holding trial court did not abuse its discretion by admitting statements in a rap video the defendant silently appeared in as an adoptive admission. Was this one of the ones that was overturned? Was this the case that was overturned? Ultimately? Hold on. This might be a rabbit hole. Maybe we can do a separate deep dive into that. I'm going to keep a window open on that. But essentially, they're saying, this person was in a rap video. He's not the rapper. He's not the one that wrote the lyrics or singing the lyrics or is lip syncing the lyrics in the video. They're just in the video. And this case, the Fifth Circuit, which is why I want to look, because I want to see if this is climbing what happened with it fully. They're saying that the trial court didn't abuse its discretion by admitting statements in a rap video the defendant silently appeared in as an adoptive admission. So Neal v. State, holding no abuse, this is 2020, holding no abuse of discretion by trial court in finding defendant's pre-arrest silence was an adoptive admission when defendant stood silent after being verbally accused of having sexual intercourse with a minor. Now, this was just in the appeals court, so I wonder if this appeal is still going up the ladder. These are recent cases, and sometimes you could see that they're still open. And they're still, maybe we're trying to take it to a higher court. United States v. Carter, from the 11th Circuit, this is older. Holding statements were properly admitted as adoptive admissions when defendant remained silent in the presence of co-defendants, discussing implicating them all in illegal smuggling activity. So yeah, adoptive admissions. I feel like this is covering 2 issues, right? The idea of not objecting in court, and then also what if we bring lyrics in? But then there's a separate standing issue when it comes to the lyrics on the rule of completeness. So what if, for example, Brian Steele wants to play the whole thing to give some extra context. You know, maybe pushing P means pushing positivity and, you know, truly humble under God. All these expansive pieces of context that Brian Steele has argued for in court. If the state is saying, we want to be able to bring in select statements, and if the defense doesn't object to those select statements, we want it to be considered an adoptive admission. But we also think Steele's incorrect for objecting to what we're doing. How does someone get out of a web like that? How does a rapper or someone involved in some way in the expression that a rapper may have made, right? They're in a video, they help produce a song. How does someone get out of that web if we let this precedent move forward? Or even just in this instant case, in this trial, if we let Love bring in select statements from musical pieces and say that not just Thug, but anybody who may have been in a video with Thug that used that song, they're not objecting to the lyrics, for the select lyrics that we're bringing in. They adopt all the activities being talked about. Like, to me, this is just stupid. This is stupid, 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 stupid. It's stupid. But technically, if there is nothing that's been decided, a party can argue it. And if a judge agrees with that party, it has a little bit of merit, at least at that trial court level in that case. And this is exactly why it's such a big deal that it used to be Glanville, and now it's no longer Glanville. Because I don't think every judge would make the same decisions that Glanville made regarding these lyrics. But yeah, this is pretty, we did get some different case law here, but it looks like they're going to, you know, the first part of all these 4 missions, like up to here, will mostly be the same. And I don't know, maybe if it's just for organization, but I don't know if it was necessary. What do you guys think? As a layperson, I'm a layperson too. Do you think it's better to break these responses into different topics? Because it's weird, because the first one we read was supposed to be about facts, not an evidence. But she started talking about vague questions and objections. But we're going to get to a 4th response where she also targets in on vague questions and objections. So I don't get why this couldn't have been one document with 4 sections on each of the things. But I'm not an attorney, so someone else could know better than I do. Let's make this 3rd one bigger. Now we're going to look at self-serving hearsay. And this one's short, 5 pages. We're getting the same footnote 2 here, the Carlson. So it looks like we're going to get repetitive stuff in the beginning. We're going to look through it to make sure we get it all right. Hey, Blue Queen TV. And then, good to see you, Chris. Q, I think I saw you earlier, but hey. And yeah, it's just, you know, is bringing lyrics going to be a foundational precedent? And there was just that case that was, it went up to the Supreme Court involving the admission of lyrics used in a murder trial against a different artist. So, like, all of this stuff is kind of new, right? And that one case that was like 2020, there was another one that was 2022. For all we know, there could still be an appeal in motion for that one that was only, it looked like it was at the Georgia appeals court level, not the Supreme Court. So we're relying on precedent here on sort of semi-charted territory. And it looks like Love is trying to find 3 different forks in the road, 3 different ways to apply this half-charted territory to create 3 new uncharted paths to take it down. That's just how I'm like conceptualizing it in my head. Let's see. Yeah. So GGT, first and foremost, they have to have the correct lyrics and know what a double entendre is. And that's extremely important when we're speaking about the rap genre, right? It's admirable if a rapper can use double entendre and wordplay in their lyrics. So, and that could be true in other genres, but it's not like a focal point. It's not a fixture of the genre. When you're dealing with a genre that is a fixture, and you're asking a jury, you're trying to insert an interpretation of song lyrics through a witness, or through your questioning of a witness, because the way Love questioned on some of the song lyrics, she kind of gave her interpretation of the lyrics in the questioning and asked the witness, yes, did you hear that lyric? Do you think that that's what that means? Have you ever heard him talk about this in real life? You're putting an interpretation of something that could purposely have two meanings for the artistic expression. You're trying to funnel vision one interpretation in front of the jury. So, half-charted territory there. Half-charted territory. it's a mess without the jury or witnesses. Heck yeah, that's a great example. Bob Marley shot the sheriff and not the deputy. And they did say in, I think it was the first, and this is confusing with them doing these 4 separate motions addressing one argument from Steele. But the first filing that we looked at from the state was about facts, not in evidence. And they gave the clarification in that document that we're not looking at these lyrics as a specified admission of a certain act. So, in a way, Love has said, we're not taking a lyric that says I shot the sheriff and not the deputy, and using that to say that the defendant shot the sheriff and not the deputy. They're using these other lyrics in a more vague way to create like some character and pattern evidence. Because it's Love. It's Love. Let me make sure I got this right. We were going to self-serving hearsay. So again, this first part might be a bit repetitive because it looks like the beginning paragraphs are plug and play, and they're just swapping the issue out. So now we're going to opposition in defendant's motion to correct rulings that Judge Glanville previously made on self-serving hearsay. So Williams requests to the court to grant blanket relief going forward on self-serving statement objections, despite hearsay prescriptions, should be denied at this time. And we're going to get that same motion cited, the June 10th with the July 10th amendment to the June 10th filing. Moreover, Williams has made no offer of proof detailing how he can possibly satisfy any hearsay exceptions attendant to self-quotation evidence. The relief sought is not ripe for review or action by this court at this time, and therefore, Williams' motion should be denied. Pursuant to Legislative Act, hearsay has been redefined as a statement other than one made by the declarant while testifying at the trial or hearing, offered in evidence to prove the truth of the matter asserted. Now, there's a whole bunch of hearsay exceptions, but what are we going to get argued from Love? A party may not introduce her or his own statement unless a hearsay exception applies. Accordingly, self-serving statements where parties attempt to introduce their own prior statements, absent an applicable hearsay exception, are routinely determined inadmissible. And that's Swan v. United States, quote, which was very recent. Looks like, they're okay, cool. So it's just something that was updated on June 28th, 2024. Self-serving statements are not exempted from the hearsay rule by federal rules of evidence, or any other exemption or exception, and are thus inadmissible hearsay. And what are we getting as a footnote? That same Carlson Code of Ethics and Code of Evidence. So, in accord with OCGA 248801C and 248802, this court correctly prohibited Williams from eliciting self-serving hearsay / self-quotation evidence. Pursuant to OCGA 248801C, hearsay is a statement other than one made by the declarant while testifying at the trial or hearing offered in evidence to prove the truth of the matter asserted. Absent an exception, hearsay is not admissible at trial. The burden is on the moving party to establish one of the hearsay exceptions applies. I think we're missing a word. So the burden's on the moving party, so it should be on Steele, it should be on the defense, to establish one of the hearsay exceptions that applies to admit the statement. Williams has not made any offer of proof demonstrating that Williams can satisfy any hearing exception applied, or that Williams is introducing this evidence for a non-hearsay purpose. Now, what's the problem here? Love is responding to this motion acting as if that motion is about a specific objection to a specific thing. And we didn't like that one objection that the state made to this statement or whatever. But what was Steele's actual motion? His motion was a little bit different than that. Let's go back to page 1 of that. It was a motion for correct ruling on improper objection by the state. Now, paragraph 2. The prosecution has made objections on countless occasions. This court has in almost all instances sustained the objections. So we have all of this. It's a pattern. And this motion is about that pattern, not a specific objection, not a specific instance. And now reading this third one, I'm starting to click that kind of what we're looking at here, and I got to find the right, where were we? This paragraph here. We're really dealing with Love treating it like a single objection in a single instance. And now that I'm thinking about it, I think we could characterize the first 2 filings we already read in that same way. That's really not what Brian Steele's moving for. So keep that in mind. Williams has not made any offer of proof demonstrating that Williams can satisfy any hearsay exception applied, or that Williams is introducing this evidence for a non-hearsay purpose. Therefore, defendant Williams' out-of-court statements, whether classified as self-serving or as self-quotation, are inadmissible. Now, this is where we get into Bruce Harvey's, if you guys tuned into those motions filed on Tuesday. Bruce Harvey was like, look, Judge, I'm using you as your own citation here to back up my argument. It would be impossible, you said it yourself, for you to go through this case's record and catch up to speed. Well, even though Love is jumping the gun here and not characterizing it properly, for Judge Whittaker to get a proper evaluation on this, she'd have to go and look at the record of these examples throughout the trial. Any of the instances where Steele or Adams or other counsel really said, hey, we object to that question. Objection, objection, objection. And then look at, well, what's your grounds for it? No, I'll sustain or overrule. Whittaker would have to go and find all those examples of those specific objections being levied. And Bruce Harvey's already challenged, can you catch up on these evidentiary and these rulings, these things that are open-ended? And here Love herself is arguing, well, there's no proof demonstrating this objection that it's a pattern. To solve this question, to respond to these motions that Love is filing, Whittaker would have to go through the whole record. So this is a catch-22 for Love, I think. This is a catch-22 for Love, and she's just hoping that someone generally agrees with it and just says, yeah, you're right. I don't know if Judge Whittaker will do that. I don't know if most judges would do that. And it might not be a big deal if this case wasn't 100 days in, but we're 100 days in, and we've had a lot of objections. So, therefore, defendant Williams' out-of-court statements, whether classified as self-serving or a self-quotation, are inadmissible. The state under OCGA 24-8-801 D2 can introduce Williams' statements as admission by a party opponent. And we're getting code of evidence cited again from Carlson and Carlson. However, this hearsay exception does not extend to a party's attempt to introduce his or her own statements through the testimony of other witnesses. God, this is all applicable to what Love does. Put a 1 in the chat if you've seen Love try to introduce a statement she wants in or evidence she wants in through the testimony of other witnesses. This court correctly sustained the state's objection to self-serving hearsay because Williams failed to address, much less overcome, his burden of proving a hearsay objection applied to his self-quoting statements. And then we have, she really tried to bring in her own text conversation with Miss Bennett. Her own conversation, not text conversation, but her own conversation with Miss Bennett. So this footnote says, see United States v. Robert, which held that defendant's statements were not necessary to alleviate a misleading impression, but were instead self-serving hearsay. Well, I think here it would be nice to get the example of what it actually was. Because what could have been the misleading impression? What's the actual scenario here? So, I mean, we're not going to dig deep into that, but that's a question I have, because I can't just trust that what Love is citing is a parallel, is applicable. Williams asserts he primarily wants to introduce defendant Williams' lyrics and social media postings, and they're going to cite the motion at paragraph 7. So this is all about paragraph 7 of that motion we keep looking at. And then, let's see. Defendant Williams' self-quotations of his own lyrics and social media postings are inadmissible hearsay. Williams has not proffered or otherwise made an offer of proof to demonstrate that any hearsay exception applies to the self-quotation evidence Williams wishes to introduce. Absent that, right, this might not be in that motion about the pattern of it all. But there have been individual objections and reasons given. So, absent that, Williams merely seeks to inject rank hearsay into this trial in derogation of binding Georgia and persuasive federal law. The state respectfully requests this honorable court deny, in all capitals, Williams' motion and request for future relief because prior evidentiary rulings on this issue were in accord with the Georgia Federal Rules of Evidence. But again, Whitaker can't know that unless she goes and reads, unless she goes and catches up. So how can she even rule properly on this? This is very dependent on the record. How can she do it? We've got one more motion from the state, you guys. It's possible, too, that we have new motions that came in, but we do have a defense filing from Doug Weinstein and co. in response to the motion to restrict the extrajudicial statements, the doing the interviews. We've got Doug's response in writing to that. He's done some interviews where you may have heard him give a verbal response. And I posted his tweet where he said, that's meritless. We're going to keep advocating for our clients. But now we've got a filing. I can't wait to read that. So this last one, let's see. Oh, this is a vague question one. So in the first motion, Love started arguing about the vague questions thing, but now we have 7 pages pertaining just to that. Let's see. And again, same thing. Are you guys okay skim reading this? They're all linked in the description. We're getting the same federal rules of evidence here. And then Williams' Sixth Amendment right to effective cross-examination is not infringed by disallowing vague questions. And then, we're getting the same case law again that we saw muddied in on the first one because they started talking about vague questions in the first filing, in the first response. So a lot of this is redundant. I don't know. Let me know if you guys want to read this one or if you guys are good. Although we do get, let's read this part. So here's an example that we're getting. So past the case law, the prior objections the state has lodged at ineptly phrased vague questions asked of the witnesses by defendant Williams have been correctly sustained by this court to facilitate ascertainment of the truth. For example, defendant Williams asked Atlanta Police Department Detective Belknap, do you know there are videos of countless performers or athletes, you guys know what's coming, where they are promoting their trade? We remembered, if you watch this trial, you remember those days. This is where we start to get into that line of questioning. Promoting their brand, wearing certain clothes, doing certain hand signs. The state objected to this question because it was vague. The question was ambiguous because it is unclear what videos, which performers, and what trade the question referenced. Court properly sustained this objection on these grounds under its inherent authority under OCGA 24-6-611. Now it might be worth maybe doing a rewatch party on these days. Because if I remember just vague recall off the top of my head right now, yeah, we start with this question. It gets objected to because it's vague. The judge is asked something different, sustained. And then we start to get into specific questions. But we still had objections, and Judge Glanville sustained some of them. So, Love is giving this one example of what may have been a vague question. But there were plenty of other objections that were sustained that followed from this first question. Even the ones that were specific. So, yeah, this is copy, like the case law and stuff is copy pasta. What we just looked at was a specific example. The argument again, and Love notes it, Williams has a problem with sustained objections, plural, the pattern of it. But we get this one example. That's one example of something that was actually vague that was probably correctly sustained. I agree. This is vague. But what happens when a lawyer asks a vague question? The next question is usually specific. But in this, and it goes, and there can be normal flow. But Love will still continue to object and sometimes not even know why she's objecting. So she gives an example that happens to work for her here. She does. But that doesn't address the pattern, if it's just one example. So yeah, yeah, maybe we should rewatch that. Because the other thing, though, is this motion was originally filed on June 10th and then amended a month later. You know, if he's speaking of a pattern of Glanville sustaining objections by the state without, you know, the proper foundation, proper grounds, there's no basis for his ruling to be in the way that he's ruling, and he keeps doing it. You know, that one day is just a drop in the water from the timeline of day one all the way through June 10th. So, so we're going to wrap that up with Love. Again, all of the documents, and I'm so grateful for Ghost, Andrea, who've been dropping the link descriptions, the documents in the chat, but they're also in the description for easy access. Let's go over to a defense filing. Let's see. Let's read something else. We're going to start looking at Doug Weinstein and what he has to say about the request to limit him speaking to the public outside of the court. And I'm going to do a quick look. Let's see if ThuggerDaily... No new motions, so we'll be right on time, I think. Right? If I refresh... Yeah, nothing new so far as other motions. So we'll be caught up with this one if we finish this one and there's no updates. So what is Weinstein? Is it Jay and Katie writing it too? Okay, so this one has Katie and Doug on it. This is from Katie and Doug. So Kendrick's opposition to state's motion to restrict extrajudicial statements comes now defendant Diamante Kendrick in the above-styled case in opposition to the state's motion to restrict extrajudicial statements, showing the court the following. We're starting with a quote. Everyone is in favor of free speech. Everyone except Love. Hardly a day passes without its being extolled. But some people's idea of it is that they are free to say what they like, but if anyone says anything back, that is an outrage. Sir Winston Churchill. I think if you decide to admit your crimes over a beat, I'm going to use it. I'm not targeting anyone. You do not get to... Oh, is this a funny quote? Guys, this is a funny quote. Hold on. I think if you decide to admit your crimes over a beat, I'm going to use it. Wow, this is a great thing to read right after those motions in response to all this hullabaloo about lyrics. I'm not targeting anyone. You do not get to commit crimes in my county and then get to decide to brag on it, which you do that for a form of intimidation and to further the gain and to not be held responsible. The Honorable Fani Willis, Fulton County District Attorney, press conference of August 29th, 2022. So, if Fani gets to use song lyrics against somebody, why can't I do interviews to defend my client and go on YouTube and talk to the public? Tell the public I think some things are funky out here. If we can have this from the DA. Quote, free speech for me, but not for thee, is the current position advocated by the Fulton County District Attorney. This should not be surprising to anyone that has paid attention. He's mad. I'm not saying, I don't even picture Doug Weinstein as, the type that gets mad in, the way that we picture a cartoon character getting mad. But I think this is Weinstein's version of being mad. This should not be surprising to anyone that has paid attention to the present case over the last 19 months of the trial. The state would apparently like the present trial to be conducted in secret, with proceedings happening in hidden chambers outside the prying eyes of the press and the public. The state has repeatedly sought the secreting of, because secreting and secreting are definitely different words. So the state has repeatedly sought the secreting of witnesses' identities, even in instances where the state has made no showing of risk to the witness, despite this court's order that such showing be demonstrated prior to blocking the broadcasting of witness testimony. Now, this was earlier back in the trial. I forget how that played out. The chat will know. They weren't showing him on camera, and then they let him go on camera, but he was wearing a ski mask, like a face cover. Right? Was that the order of it? One of the detectives? You guys will know better. I know Julie will know. Julie will know. And then let's see. After attacking the integrity of respective counsels for defendants and witnesses, and again, you're not supposed to attack the integrity of the other lawyers, not just for the defendants, but also for people like Kayla Bumpus. You're not supposed to attack her integrity. Repeatedly calling the Honorable Brian Steele a liar and accusing the Honorable Jonathan Melnick of working for defendants rather than his client, Kenneth Copeland. The state now turns its attention to counsel for Diamante Kendrick. Oh, we did a typo. But to paraphrase President Truman, counsel does not give the state hell. Counsel just tells the truth about them, and they think it's hell. In a 1.5-page motion. Oh, that's shade. Why was it 1.5 pages, you guys? Who can answer that? Oh, okay, let me correct myself. That was Y&W Melly, where the detective was scared and was able to go up with the face mask. And I think Jade Chill has the same idea. Y&W Melly, not Nelly. Nelly probably auto-corrected. Ah, yes. Yes. Why was it only 1.5-page motion? Which is very funny when you consider how long the oral arguments are when it comes to love on the courtroom floor. But it was a 1.5-page motion because she didn't even give any examples of what would have been prejudicial, what would have been crossing the line. She just gave footnotes with exhibits that were links. The exhibits were links to YouTube interviews on Megan Cuniff's channel and I'm Not a Lawyer But's channel. But in her actual argument, she made no argument of what statements were made that were inappropriate. Why? Why didn't she include any statements of things that Doug Weinstein may have inappropriately said? Why didn't she include them? There's nothing she could include. She just wanted to make the motion and hope that somebody would go, oh, yeah, it would be bad. We're just going to assume that they were making improper statements. And we think also that it's bad to make improper statements out of court. So we're just going to take it all at face value and say, yeah, we shouldn't be doing that. Yeah, there you go. That's it, Coco. There are none. Someone go find a quote from Doug Weinstein somewhere that really crosses the line. That's inappropriate. Love had a week. Didn't do it. And I'm sure she was watching some of them too. It's not like she had to go and find something she had no interest in. She was watching them anyway. It's not a waste of time if she's doing it anyway. So this is so funny to me that they say this. In a 1.5-page motion, the state cites to Rule 3.6 of the Georgia Rules of Professional Conduct and cherry-picks certain comments to the rule to support its motion to, quote, instruct the defense to refrain from making extrajudicial statements about this case moving forward. No case law cited. No finely tuned order is proposed. As the state accurately quotes, Rule 3.6 bars lawyers from making extrajudicial statements that a lawyer knows, or reasonably should know, have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. The state provides no specific quotes of Kendrick's counsel that might be barred by Rule 3.6. Instead, the state invites the court to go on a scavenger hunt among 208 minutes of interviews to find statements by Kendrick's counsel that might arguably violate Rule 3.6. The court should decline this invitation. Remarkably, the state does not make a single argument that any statement by Kendrick's counsel meets any of the elements of Rule 36. They do nothing, because it's a 1.5-page argument, including her signature page, or like the little thing at the bottom, because she doesn't use a new page for her signature. Instead, the state simply offers up a single conclusory statement. There is no argument that any statement made by Kendrick's counsel was known to, or should have been known to, have a substantial likelihood of materially prejudicing this jury. No argument was made because no argument can be made. Oh my god, put it in a neon sign. Put it in neon lights. No argument was made because no argument can be made. Oh my gosh. You know that like thing on Twitter? Like the quote bot? Where you can like put something in like a really deep artistic looking like black and white photo and it just puts the text over it. I need to do this for this quote. No argument was made because no argument can be made. This characterizes like the whole trial. The present jury had been impaneled and hearing testimony for months before any statement was made. The jury has been instructed at the conclusion of every day of trial by Chief Judge Glanville through his ad nauseum admonitions to not discuss the case with others or with each other. They have been instructed daily to not consume any media about the present case. No statements made by counsel for defendants can be heard by the jury to prejudice the jury. And 1. The only improper prejudice to the jury has been through the repeated eye-rolling and facial expressions of ADA Love, who is sitting feet from the jurors. Oh, that footnote was for you, Julie. That footnote was for you. Oh my gosh. Yeah, and hit the like. Thanks, Julie. Oh my goodness. Tay Biz, thank you for gifting some memberships. You guys say thank you in the chat. Gifts are so cool. I think that's so nice that I really love that feature on YouTube. It's my favorite thing. So thank you so much, Tay Biz. Tay Biz, now you have to read, you have to do a stream on this because this is hilarious. Doug's cooking in like a really nice, in his way. This was definitely for you, Julie. This was for you. All that eye rolling, the body language sitting right there at the desk. Because if you guys remember, we're looking at, when we look at those videos from the, you know, it's like the back of Hilton's head, the back of Love's head. The jury's literally like right to the left, out of frame. Like ahead and to the left. So kind of like it runs along where the witness booth would be and that first table. It runs alongside, right on the side right there. There's enough space for a witness to walk up through a little pathway on the floor to get up to the witness booth. The jury's right there away from Miss Love. And she's not like how Christian Adkins usually is. He doesn't really make much motion. We saw him really animated that one day. Love is always like, ah. Like, you can tell. And honestly, it might make you look at her instead of looking at the witness. And a jury should be paying attention to what's actually happening because they can judge a witness by their demeanor, by their body movements. You know, that's why we always say transcripts don't do the same thing for a trial that actually being able to watch it can do. Because when you get to watch a witness make weird motions while they're saying something, you could say, you know what? They look like they're being shifty or shady or lying or not telling the full truth right now. And it's the jury's right to decide if they think a witness is credible or not. So, the prejudice, her eye rolls can be prejudicial to the attorneys. If she's rolling her eyes after the attorneys object to something, that is prejudicial. It can also impact the jury's ability to pay attention. And a court always wants to make sure their court doesn't have interruptions or distractions, people snacking on oranges and being loud. Because the jury, the best way for a jury to make the decision is to pay attention to what they should be paying attention to. This is a great footnote. I really love Doug and Katie. And Jay, even though he's not part of this one. The body language is terrible. It is so good. It is hilarious. The pulsing vein. Yeah, they can probably see that from the jury booth. Can you imagine like the jurors' notes? They have like their drawing to pass the time in one of the notebooks. One of the drawings just has all the details of Miss Love. That's how close they sit. Oh my goodness. Doug Wine Slime. That's hilarious playing Mary Jane. Definitely cooking. Oh my gosh. Well, let's keep going. Let's keep going. I don't have popcorn, but we'll pretend. So where was this footnote attached to? It was like somewhere up here, right? Where were we? 100 witnesses? Yeah, okay. So no statements made by counsel for defendants can be heard by the jury to prejudice the jury. The state invites this honorable court, which is trying to catch up on hundreds of orders, many of which are provisional, 19 months of trial, over 100 days of testimony, and testimony from almost 100 witnesses, to wade through hundreds of minutes of interviews, find statements of Kendrick's counsel that might be objectionable, determine what Kendrick's counsel knew or should have known, and summon a reason about why and how they could materially prejudice a jury that is barred from, and admonish on a daily basis from, consuming media about the present case. This honorable court should respectfully decline this invitation. Now, this sentiment here echoes, we've talked about it already, and Tasker66 said earlier in the beginning of the chat, I think it's possible that that Love is doing all this because she wants a mistrial. Love might embrace the record is too complicated argument because something like that could warrant a mistrial, but not necessarily with prejudice. But if we have to consider these other reasons, like misconduct of the state, of the previous judge, that mistrial with prejudice is still on the table. But I think that was a good point because who can dispute this? Who can dispute this? And whether out of ignorance or carelessness, or maybe it's actually intentional, Love is saying, hey, go look through hundreds of minutes of interviews. Go do the research on things that aren't even part of the record and start considering another issue outside of what's already on the table for you, Judge Whitaker. So Doug says, Judge, decline that invitation. Don't do all that. In addition, the state conveniently fails to quote from the presumptively safe harbor comments included in Rule 3.6 that permit Kendrick's counsel to speak in public on his behalf. Rule 5BA reads that there are certain subjects which are more likely than not to have no material prejudicial effect on a proceeding. Thus, a lawyer may usually state information contained in a public record. Each statement made by Kendrick's counsel relates to publicly available information in the public record of the present trial, which is being streamed daily to the public. To the extent there are any remarks not specifically in the public record, such statements are general remarks, intended to demonstrate that Kendrick should not be on trial. Justice Kennedy rightfully understood the present situation that Kendrick and his counsel find themselves in. Kennedy wrote that an attorney's duties do not begin inside the courtroom door. He or she cannot ignore the practical implications of a legal proceeding for the client. An attorney may take reasonable steps to defend a client's reputation and reduce the adverse consequences of indictment, especially in the face of a prosecution deemed unjust or commenced with improper motives. So, we have a right to talk about this. If there's unjust things happening with the prosecution, or the motives aren't proper, we have the right to talk about that too. A defense attorney may attempt to demonstrate in the court of public opinion that the client does not deserve to be tried. So my client is innocent. And then he also gives this quote here that we're going to read from Gentile v. State Bar of Nevada. Justice Kennedy also correctly notes that the police, the prosecution, other government officials, and the community at large hold innumerable avenues for the dissemination of information adverse to a criminal defendant. By contrast, a defendant cannot speak without fear of incriminating himself and prejudicing his defense, and most criminal defendants have insufficient means to retain a public relations team, apart from defense counsel for the sole purpose of countering prosecution statements. Great point here, right? Because, the police is really, they're part of the state. When you think about prosecution, kind of have your policing agency who puts reports together. They give that report to the state. It's an arm of the prosecution. They have all this stuff. They have subpoena power that defendants don't have. They have incredible power and resources to get all the things that they want to get. They get to make press statements. They get the initial, and maybe they're losing this a little bit, but generally, when a statement comes out from, a sheriff makes a statement about why someone was arrested, or a DA comes out and says, this is why we're indicting someone, we're pressing charges against this person. Generally, those things are highly broadcast and they're pretty trusted. They come inherently with a level of credibility. On the contrast, A defendant might have a mugshot, trying to make a statement, trying to say that they're innocent. They're told not to speak because that could all be used against you. And if they do make a statement, that news article is going to put a photo of their mugshot. They're in the jumpsuit, sitting there in the picture. So the defense is already at a disadvantage, and that's exactly why we have quotes from Justice Kennedy that say things like this. We've got to make sure we protect the defendant, not just because they're at a disadvantage, but they're really the one entitled to the fair trial, constitutionally entitled to it. We get more. These are great. I love this. So Justice Kennedy cites the important role that defense counsel plays in educating the public on pending cases, writing that because attorneys participate in the criminal justice system and are trained in its complexities, they hold unique qualifications as a source of information about pending cases. Since lawyers are considered credible in regard to pending litigation in which they are engaged and are in one of the most knowledgeable positions, they are a crucial source of information and opinion. To the extent the press and public rely upon attorneys for info, because attorneys are well informed, this may prove the value to the public of speech by members of the bar. If the dangers of their speech arise from its persuasiveness, from their ability to explain judicial proceedings, or from the likelihood the speech will be believed, these are not the sort of dangers that can validate restrictions. So neither of these things are issues. So just because an attorney might be persuasive, just because an attorney might say something in a way that a layperson can understand, and just because the attorney can say something that seems credible, that will be believed, these are not the sort of dangers that can validate restrictions. The First Amendment does not permit suppression of speech because of its power to command assent. And I want to give the flip side here. Can you guys think of any example where a lawyer has pissed you off, a lawyer has made you dislike a defendant, and you have to remind yourself, well, damn, that sucks for the defendant. Their attorney's really not making it look good for them. This power isn't a universal advantage for a defendant or the defense attorney. It can, has its cons, has its downsides. So it's not just like I'm sure Love thinks it's like some free-for-all winning fest for a defense counsel to be able to make public statements, and that they should just be quiet for the entire duration of a 2-year trial. Shouldn't say anything, no public speech for you. But at the same time, if you have if you don't watch what you say, or you're a dolting, bumbling idiot, or the evidence isn't on your side, or the case law isn't on your side, and you're an attorney that wants to give a bunch of interviews and put yourself up on a pedestal, the public's going to think you're an ambulance chaser. They're going to think your client's not credible. It goes two ways. And Love doesn't seem to realize that. This is the exact situation that Kendrick and his counsel find themselves in today. Kendrick is a public figure who is an artist. He writes, records, and performs rap music and lyrics. In Fulton County, this makes Kendrick a target of the state. Oh, and that's why we opened with that funny quote. Kendrick is allowed to take reasonable steps to protect his reputation, and those steps may be taken by his counsel rather than through a public relations firm. Having smeared Kendrick and his reputation, the state wants to silence him, initially, by placing a burden on his free speech rights to write about the world in which he lives, and the tragedies and injustices around him now. And now by holding press conferences denouncing him and his writing, while subsequently seeking to bar him from defending himself in the court of public opinion. While the state has unfortunately been successful in impermissibly burdening the free speech of Kendrick by limiting his present and future writing, the state should not be allowed to bar him from defending his reputation. Wherefore, Kendrick prays that the court denies the state's motion. And we got this from Katie and Doug. Whew. Shout out to Doug Weinstein. That's his version of going like scorched earth, burning the house down in his own way. Hold on, do we have an update? So ThuggerDaily posted it looks like a parody or maybe a real song, Letter to Glanville, but I'm not going to play it in case it uses like a copyrighted beat. But there is a new tweet from ThuggerDaily with a song. But let's see. Heck yeah, shout out to Katie. It's really important to have a good writer. So if that's Katie's role, like, she is crucial. And then, let's see. Tavis says they are tripping. I actually find it insulting that the motion pretty much shut the defense up was fine. Yeah. And that's why, I mean, it's not weird that they're not including case law, because we've seen some arguments where they don't really put case law in. Both sides have kind of done that. But the fact that they didn't actually give an example of something that would be prejudicial, it just, to me, it just shows the issue is Love's feelings getting hurt. Like, she's really sensitive. And then, let's see. What are you doing, Tay-Biz? Do you want to come on motions? Let me put in, where did I put my headphones? I have my gamer headphones. You guys are going to see me put on my big clunky headphones. Come up, Tay. I'll lock and load. I'll drop a link. So this StreamYard link is only for Tay and anyone else that's guessed it up on the channel. Or if Drea and Ghost want to come up, they can come up. But let me know. There's a link in there. But yeah, that was really, it was like good writing. It was like nice to read. It was pretty short and concise. Even though I think that was the longest, one of the state's responses was 7 pages. But this read faster, even though I paused more than the other motions. Heck yeah. But that's the interesting thing, right? They can't make the argument to block the interviewees. They can't make an argument against Megan Cuniff. They can't make the argument against I'm not a lawyer, but. And I know and Sylvia was cited in there too. So, Sylvia, if they wanted to I saw people saying that they were trying to get Sylvia out of the courtroom, and I haven't seen anything that's objecting to her Rule 22 access. I think people misinterpreted what this motion against extrajudicial statements by defense counsel and defendants actually encompasses. That argument is only applicable to the defense and their counsel. So unless there's an extra motion out there that's, Judge, we need to get Sylvia out of the courtroom, revoke her access or whatever, which I haven't seen. I don't think that that's actually happening. I could be wrong. But this motion from the state doesn't apply. It doesn't contain that. Andrea's at the beach. That's awesome. Well, relax. Thanks for being so hardworking in here. That's so nice of you. But enjoy your time on the beach. I live near the beach and I never go. That's funny. But, it would be a totally different order if they wanted a protective order. They don't want the cameras in the courtroom anymore. I don't think Judge Whittaker would go for that at all. I don't think she's going to go for this extrajudicial statement thing. There's no basis for it. It's really meritless. I completely agree with Doug Weinstein. Completely meritless. But she filed the motion, and it just shows she's sensitive about something. And I don't think we've got... So those footnotes, those YouTube videos, it looks like all of them were like 7-second statements. So now Love is getting like fine-tuned on the YouTube clips she's citing to. So nothing really in the footnotes to go ahead and replay. And then... And M. Shannon joining us late on the replay crew. Can't wait. Comment your reaction, because this might be done by the time you're hearing me say this. Comment your reaction to Doug's motion in the regular comment section. I'm excited to see what you think. And we're going to get Tay-Biz up here. And Ayana, yes, that's exactly outside of court. That's exactly the distinction. It's for the defense counsel. And yeah, there's no way. Can you imagine? Guys, can you imagine? Okay, 900 of us are sitting in here right now. Can you imagine if an announcement came down that Judge Whittaker grants no more cameras in the courtroom? Can you imagine the response? Like, obviously, the defense counsel would burn down. They'd go scorched earth with their motions. But can you imagine what the public would do? We'd be... Oh, that would not be a good time for the court. They'd be so stupid to do that. Talk about eroding public confidence. What little is left. Oh my gosh. So let me clarify to anyone that just heard that was absolutely just a hypothetical. There has not been a decision about that. There's not even, I don't know of an argument, a standing argument right now to get cameras out of the courtroom. It's just a hypothetical. Let me see. Tonight it is Friday night. And I think I'll be able to hop on with Nick Starro for a little bit. So I did just drop a link to a stream that Nick Starro has planned for about 4.5 hours from now. So he's going to have a panel of guests. I'm sure this will be a topic. I also think the Ashley Benefield trial might be a topic, which is interesting because the judge in that trial yesterday, maybe it was 2 days ago, maybe it was on day 2, there was an attorney witness. Ashley Benefield may have murdered. She's on trial for possibly murdering her husband. It's an affirmative defense, so she's agreeing that she's the one that killed him. But she's asserting self-defense. And they had an attorney witness that I think was part of their divorce case who was a witness. And as part of that, she said something that triggered the judge and the defense and the state. They all had to get the jury out of the room. And suddenly the judge orders a transcript of an in-chambers meeting from a different judge, from a different courtroom, from a different proceeding. And they're speeding it along, and they're getting that transcript right away from the court clerk because they got to see what happened in there because it's relevant to this case. And it's just like, dang, this guy's ordering ex parte transcripts or in chambers. The defense may have been present for it, but in chambers transcripts. And they're coming in with the quickness. No problems with it. And look at what we're sitting here a month and a half waiting for this trial to figure itself out. It's crazy, crazy stuff. If you guys are watching, yeah, Julie, the cameras go out of the courtroom, Mr. Steele voice, I would die right now. Oh my gosh. But yeah, so watching the Ashley Benefield trial, it's speeding right along. One of the witnesses, the deceased, the Ashley Benefield, Doug Benefield, Doug's deceased, Doug's daughter was apparently speaking to a reporter in the hallway. It may have been overheard by jurors. A lawyer, a reporter, went and spoke to an attorney to send in an anonymous letter saying like, hey, I noticed someone that I recognize as a juror was standing nearby. They were at this restaurant for lunch while the TVs were playing and the court case was on and other people were in the restaurant speaking about this case. So like in that case, there's all of these like, everyone's trying to do the right thing. And it's so different compared to what's going on right now with the YSL trial. Super, super different. So I'm sure that will be a topic of discussion on this panel tonight. 2 of the panelists, I think, have been following the Ashley Benefield trial. And obviously, you guys know Nick has been following every detail of the YSL case. So if I jump on there, I'll be there for, maybe about an hour tonight, starting at 6. So let me drop that link one more time if you want to bookmark it. And then Tay-Biz says he's going to jump up. We're going to talk about these motions, and maybe he can give us some insight on what's going on with Boozy. Oh, Eric, I get to see you. I recognize your picture. So you changed your handle. Now I got to learn it. So she loves fantasy. I'm still going to call you Erica, but I'll try not to. I'll try to adjust it. I'll rework it. All right, guys. Do you think this case is going to be dismissed? We'll get the vote going. Tay-Biz just joined. Let me know when you're ready, Tay. And then I think it should be dismissed. I think it should be dismissed with prejudice because of the length of the trial and the causes of why it should be dismissed. There are some reasons it should be dismissed that in an ordinary circumstance without anything else going on, there could be a mistrial that should be retried, right? It's a manifest necessity to start the trial over if the judge can't catch up mid-trial and go back to the beginning of the record and get caught up to speed. It's manifest necessity. We have to do a mistrial. It's just impossible to do it the right way without. We have to do it again. And because we had to call a mistrial for a manifest necessity, there can be a retrial, right? Those are if you take things in a vacuum. But if we think about the other things, prosecutorial misconduct, judicial misconduct, I think those are really valid arguments. I think the facts support that there was a misconduct, and I think it should be dismissed with prejudice. Do you guys think the judge will dismiss with prejudice, dismiss without prejudice, or will keep going? And you good, Tay? All right, so there we go.
What up, though? What up,
Hi.
though?
Hi.
You good? How are you?
Good. Chat, let me know if my
KattNotWilliams.
microphone volume sucks, because sometimes my guest is quieter than me and I'm screaming. But let me know.
Do I sound okay?
You sound great.
Oh, okay, great. How you doing?
Tell everybody what you talk about on your channel.
I talk about a lot of things on my channel, especially YSL. I've done some things. I've done some Lil Woody videos. I talked about Alec Baldwin trial as well. That was very, very interesting trial.
Right? Jam-packed for 3 days worth
I
of
mean, 3
trial for it
days
to
of
end.
an 8-day trial that ended in 3 days is like, okay. And also had yesterday, was it yesterday or Tuesday? Tuesday, I think I interviewed Maggie, the substitute teacher, on my channel. We
Oh,
talked
cool.
about femininity, dating culture, and stuff like that as well. So
So
I have a
you
variety of things.
get
Yeah, it's a
yeah,
variety. I'm interested in a lot of things. So I don't just shield myself to just saying, okay, court stuff, or just like rap
a
stuff, or just like
multi-topic discourse channel.
multi-topics. You feel me? Multi-topics. Yes, yes, absolutely. But this is very crazy. These motions are ridiculous. And I think Attorney Love, she just needs to go ahead and wave the white flag and give it up. Because
See,
low
I
key, I mean, the motion to disqualify them are still out too. You know what I'm saying? To disqualify Hilton and Love. So
do you
even if they
think
do,
Whitaker will just, if she's going to think that we're going to mistrial, do you think she'll just address that and skip all these other motions? You think she'll
probably,
entertain oral arguments for other stuff?
yeah. Because if she disqualifies Love and Hilton, then all other motions really wouldn't matter in a sense, because you're going to continue, either you're going to continue
And
with
the jury,
new,
without a mistrial, the jury's still sitting. The
right.
jury would be waiting.
But see, the thing is I can't trust how can you trust the jury at this point to even remember all the things that have been going on for the last 19 months, or the last since January of
And you
this
got to
year?
tell them to forget Dumbo.
Right, you gotta like, don't, whatever Woody said on the stand, don't worry about it, just forget it, erase it out your memory. You think they're not looking at YouTube? You think they're not looking at X? You think, come on now, of course they are.
Well, I
Even
mean,
the
you're
lawyers are looking at
essentially
YouTube.
asking them to do nothing for
Right,
the approaching 2 months.
right. It's crazy. So
What do you
I think
remember? Like what I remember, if I think of memorable moments, besides
mhm,
things that are like attorneys fighting where the jury was out of the room, right? Because we
mhm,
get to see that, and it's no jury was present when Brian Steele's like,
mhm.
"This is communist
Yeah, yeah.
Russia."
He
Like
says
that's
communist
not
Russia.
memorable to the jury because they weren't there.
Right,
But I
right.
remember the "I'm so high right now." What? And some people said they
Yeah,
couldn't understand what he had said. But I heard it watching it live. I
yeah,
understood it without it having to be replayed or repeated to me. So if I was a
yeah,
juror, I'd remember that.
yeah.
Um,
You remember
I
Woody standing up in chains, leaning back like he about to faint when he was trying to find out where Shannon
and then
was.
say he doesn't drink water. I don't
He said, "I
drink
don't drink
water.
water."
Who would not remember that?
Exactly,
The court
exactly.
reporter interaction, like you're gonna remember Woody because he was
You,
interesting, and you're gonna remember
hmm
the specific quotes because the quotes themselves were like,
hmm
"What? Did he just
Yeah,
say
they were
that?"
crazy. Yeah,
And
I
then
mean, he
some of the
basically
other
said,
mentions.
"Oh, I'm sorry."
No, go ahead.
No, he basically said, "Hey, whatever I told the investigators at the time when they interrogated me, I don't remember because I lied the whole time." The funny part is, like, okay, what was really crazy to me is, and this is when the jury was not present because they were doing the hearings to admit certain things in evidence, that long video, that 19 hours or whatever it was, 11 hours of
Yeah.
interrogation, whatever crazy number it was. The fact that they were trying to admit an interrogation that he said he lied about to see if it's actually true that's where you're trying to throw things at the wall to see if it stick. You're just slapping anything on here. It's like he had to tell the truth at some point in these lies. It's like you got to fish through all these lies to find at least one or two things
Well,
that's true. Come on now.
they're preying on it's the jury's role, it's the jury's right, it's the
Mhm.
jury's
Yeah.
freedom to interpret and weigh the credibility of anything that they're looking at. But
Mhm.
there's rules of evidence and rules of admissibility for a reason.
Yeah,
And I
absolutely.
would say strategically, I think it was a piss poor strategy for the state to even want to play something that was that duration with that
Exactly.
sound quality that's that hard to pay attention to and that boring. They should have wanted to prune it down and point out
Absolutely.
specific things. That way they could jury, pay attention right here. Pay attention to this.
Mhm.
Stop and ask questions about certain parts. It's
Mhm.
just like it just
Yeah.
doesn't seem strategic for the state to even do
It's
it that
not.
way.
They don't have a strategy. That's the whole point. And I think that okay, so being in IT, I've been an IT professional for over a decade. So there was a time in my career where I had municipal tech experience, and I remember like police officers that needed evidence and videos to be condensed and all that kind of stuff. You can't doctor those things up. You know what I'm saying? Uh-oh. Anybody what happened to Cat? Uh-oh.
I'm here.
Cat, let
Sorry.
me.
It froze my window.
Oh, okay. I'm like, Cat about to let me rock out. Okay, cool. Let's do this now.
It's your show.
Right.
I was hitting the invite button to grab the StreamYard link in case, because I'm sure it's gone in the chat. And when I hit the invite button, it just like froze out the thing.
Yeah, but no, I was just saying that you know, in municipal
she
tech,
found it anyway.
Hello.
Hi.
Hey, how you doing?
Good.
I'm on here with some heavy hitters, man. I feel like a little dog. I'm a little dog.
Yep.
So I know you're not a lawyer, but what else are you? What are you actually?
I'm a mom and a wife.
Okay. Mom and a wife. So you know how to argue.
Yeah, that.
And I think we had Drea drop your channel. I'm going to drop your channel in the description. I think a lot of people are familiar with you, but besides the YSL case, what do you talk about?
Oh man, I talk about everything that's legal in law, even though I'm not a lawyer. My goal really was to just recap for people what's going on, like what happened, because most people are busy doing other things. And so it really was to just give a recap of like, hey, this is the craziness that happened in YSL, in YNW Melly, in Alec Baldwin. I know y'all were just talking about that. So that was really, that's the goal.
I love that 3-day Alec Baldwin trial. Really easy to recap. Super easy to recap.
Oh, so good.
Oh, and I think Dennis Byron just popped in. I don't see your video, Dennis. So when I see your video, if I can get a thumbs up from you when you're ready, we'll bring you on too. Nice. So that'll be good. We'll have a 4-panel. It'll be all squared out.
Okay.
A little bit Hollywood Squares starting.
Yeah.
And it says he's got the mute button thing. So let me see. Maybe he'll send a private message. Send a private message, Dennis. But yeah, are you guys watching other trials besides waiting for this right now?
There's one trial that's been going on with the lady that stabbed her husband in the heart. Mm-hmm. She was defending herself from him,
Courtney
I believe. No, it's a Ricci. I think her name is Rachel Ricci or something like that. Or
is that Massachusetts?
Case. Yeah, I think that's in Massachusetts. Yeah,
that's not the one who got on the stand today, though, right? I think there's two cases of women killing their partners, and one of them she got on the stand today.
Oh, is that Ashley Benfield? I didn't watch today yet. Oh, that's gonna be good.
Yeah,
that's gonna be good.
Yeah,
I'll be on replay crew to catch up on that. Let's get Dennis Byron. You good, Dennis? Thumbs up. I don't know if he's nodding. We're gonna bring him up.
Hey,
good to see you.
I'm good. Stand by. Let me close some of these windows. I think I hear feedback.
Okay. I don't hear feedback for you. Do you guys hear feedback for him? Yeah, close. You've got me on YouTube somewhere, it sounds like.
Yeah, I know. Let me fix this.
Heck yeah, all-star show.
The fact that I'm included in the all-star is actually humbling, to be honest. So
I love it.
I love your channel. I had a great time over in your chat too. I thought like Drea was over there. I knew some familiar people, but even the people I didn't know, everyone was like cool to hang out with, very thoughtful. I love my chat rooms.
Oh yeah, the chats are awesome. Love the chats.
I think we're good now.
All right, Dennis. So we're longtime friends on Twitter, but for anyone that doesn't know Dennis Byron, who's Dennis Byron?
Oh, Dennis Byron is a journalist, a investigative reporter, and I've covered many trials over the many years, over 30 years of trial coverage. Okay. I just call myself a media professional. That's it. A lawyer, not a lawyer, is doing. Mel, you doing some good work out there, Mel.
Thank you.
Big time. Big time.
No, those recaps are important.
No, Kat, you doing good.
Absolutely, Kat's out here.
I'm the long-winded conversation.
Oh, you're so good.
I like
that is awesome.
I like the fact that I'm in the courtroom, but I'm noticing that you are on top of these docs. You're on top of these docs.
Yeah.
I commend you for that. You're doing a great job with it. And between you and Thugger ThuggerDaily. You know?
Yeah, he's actually grabbing the doc. So I love for other cases, I've been doing the records request, grabbing documents. But ThuggerDaily has been getting them like expeditiously is the best word to use there. Like just quick. Even on like, hey, there's a new filing. Fulton County doesn't want my money. They won't let me enter payment information to download.
Well, hold on. I didn't know if you were aware, but the documents are available for free. We have a link that you can, once they upload it, you just pull it like that. Send
me a DM because then that way I can get some.
They didn't tell you that?
I'm still paying. I have one alert set up so it tells me when something's in, but I'm still paying.
Like the Odyssey portal, right?
No, I'm going to send you the link. It's under the high profile cases. I've requested for certain cases to be in high profile where you don't have to pay if you're a member of the press.
Oh, sweet.
Okay.
Should I be telling you that? I don't know. I hope nobody get mad at me.
Yeah, of course. You should. Absolutely.
You should tell us.
Of course you should tell us. Absolutely.
So you can pull the documents up immediately. They upload them right to that section. It's only probably about 15 cases that the Fulton County has put in the high profile coverage section.
The Ricos and
definitely Ricos.
All the Ricos. No.
Yeah, all the
cool.
Ricos.
I mean, they should.
So you
COVID made a lot of courts make accessibility a little bit easier, but this portal is always finicky for me. It just would never let me create a payment account, and I would see that if I was able to, it would make me pay. No wonder. Shout out to ThuggerDaily anyway for doing the legwork. But I was like, oh my God, this is 100 and something pages. It was the one that had a transcript as an exhip. So I was like, I'm gonna send you like $100 for this right now because I usually send like 20, 25, just to support, not for the documents itself or anything like that. But I didn't know there was a freeway, so hopefully ThuggerDaily knows.
I hope I didn't knock someone's hustle.
No, I'm still gonna support anyway. Still gonna support. No, because it was never for the documents. It was for the coverage.
Well, you're doing a good job, and I think that you're doing a good job. I think if you guys are reporting, you want to report in real time. You want to be able to have access to the documents as they come available. And I've requested certain cases that are high profile, make it accessible, because sometimes the Odyssey system doesn't work. It doesn't work.
I've had that issue with Odyssey for other areas too, because they're in a few different counties.
AV, what's going on? Did you make that available yet? It's available, AV. The lead, lead knows, but I'll shoot you the link. But documents are available, like right away.
Yeah, and AV, I dropped the StreamYard link in the chat if you want to pop up. Thank you for the super chat. And yeah, we're just learning. If you just jumped in the chat, Dennis Byron was like, look, there's a thing for high profile cases. You don't need to deal with all this janky document portal stuff. Because AV's had the same issue. It wanted her to create this payment account and then wouldn't actually let you input any information. They were calling us broke. They said, we don't want your money.
Right. I had the same issue. I was like, wait a minute. I kept refreshing my window. I'm like, wait a minute. Is it me?
I'm going to
drop page one.
I'm going to drop the link in the private right now. I'm going to pull the link for you guys. I thought you guys knew this. I'm sorry.
No, that's okay. And I've got to say, like, I wish more places did this.
Yeah.
I know. And the documents weren't necessarily free, especially not all of them. But for the Depp v. Heard trial, Fairfax had a high profile section where some of the current documents were available. They would prune it down if you didn't grab it right away. And there's an archive, depdive.net. I think it's in .net. All the documents from both trials, just incredible. And they spent a lot of money to put that together. But a small portion the county did make available for free because it was high profile. So I appreciate when counties do that. Stuff should be accessible.
Absolutely.
Well, this is how they make their money. It's clerk's office. But a big county like this, a high profile case, just imagine having to pull a transcript.
Just getting bogged down.
Yeah.
Okay, so I'm gonna put the link here so you can share if you want to share it. Put in the private chat.
I think I just.
Do you want it shared to the regular chat? The whole chat? Because you have limited. Will they know your bandwidth?
They may start charging after that.
Yeah.
That point.
So chat, duly note this, because sometimes they'll notice bandwidth to a certain portal, they'll shut it down.
Yeah.
But
so I said,
in addition to ThuggerDaily, you will have Tay-Biz, you'll have I'm Not a Lawyer But, and myself all able to get these things. I'm going to DM AV since she's not in the private chat. AV, I'm sending you a DM. Thanks for sending gifts. I'm pulling this up right now before I lose the link. I am DMing you on X, AV. So you will also have this link, thanks to Dennis.
Yeah, so you have that link.
Sweet deal.
But that's been
Appreciate you, sir.
crazy. I appreciate you, Dennis, for like your coverage on X anyway.
Yeah.
Do you do YouTube?
I do YouTube. Actually, I do Hip Hop Inquirer at Hip Hop Inquirer. But I'm on Twitter a lot. You know, I'm on Twitter a lot.
I got to get my Twitter game up. So many of y'all are doing everything on Twitter. It freaks me out. So
Mel, you TikTok, aren't you?
I'm a TikToker.
Okay. Any threads in the building?
No, I tried. It was too
way.
life coachy.
Yeah, no way.
Yeah, they're carbon copy.
Let me do this properly too. Thank you for the super chat, AV. But here we go. Thank you so much for gifting the membership.
Wow,
so nice of you to do.
Hey.
I saw a comment, it's gone, but AV did mention she's going live with the lead attorney soon. I can't redirect to lead attorney. Maybe I can now. I'll double check. But just know that that's going to start on lead attorney's time. You know how that goes. But that will be starting at some point, sometime soon. So shout out to AV. It was nice of her to stop by.
Hey,
sure.
And then what, Dennis? Sorry to Tay and to Mel, but you're like the man of the hour right now. You've covered all these other cases. What's something else interesting that you've covered?
I mean, where do we want to start at?
Pick like a top one.
I just finished covering the Tiana Taylor and Iman Shumpert case.
You did.
Yeah, that got over close to 9 million on one post, 9 million on one post. That was pretty high profile. A lot of criminal cases. I sometimes I lose track of so many cases I've covered over the years. I've covered Tupac when he was on trial. I covered Diddy when he was on trial in New York. I've covered Larry Davis, O.J. Simpson, a bunch of cases, a bunch of trials. So the way cases are covered now is so different. You know, we didn't have YouTube back then. So this is crazy for me. Like I watch this now, and I actually have shot a lot of the court cases as an independent journalist in Fulton County. Probably have more videos than anybody in Fulton County that I actually own. So some big cases there. Usher, when he was on, him and his wife was on trial. Ludacris, Cheesy, Allen Iverson.
What an interesting city to be based out of too, because that's when, you're in the courthouse for all that.
It's crazy because these other districts, jurisdictions don't want cameras in. I think cameras are so important. It's so important.
When you did the New York coverage, was that cameraless?
Did he? No cameras. You had we had a still photographer that came in.
Expensive records, expensive to get copies in the New York courts. Crazy.
In California, the same way. Covering I covered the Tory Lanez trial. You definitely have to go down to the basement and get the documents. You had to set an appointment to get the documents. Megan Kuniff knows. So there, certain places you can in the federal, of course, federal court cases. You can't no cameras in federal court. So you literally have to just sit there and take copious notes, and and it's the structure is so different than a Glanville courtroom. The structure is so different.
Oh yeah. Well, and speaking of that, I mean, with federal trials, there really aren't supposed to be extrajudicial statements from any of the attorneys, the parties involved. So you won't even get insights from the trial counsel when it's a federal case.
It's interesting, Kat, that you bring that up. So when you notice I haven't tried to interview none of the lawyers because I know this. This is why I'm like, you guys are really talking. Some of the attorneys I've seen cover other cases know they're not really supposed to be talking. You don't want to trigger a gag order. This is why I don't really try to interview lawyers and definitely not witnesses that are actually in the case.
Well, and you might have heard the Ashley Benefield trial. They had to eat up like an hour of time yesterday polling the jury to see if they saw the daughter of Doug Banfield. She'd already testified, but she was on the list to be recalled possibly as a rebuttal witness. So
wow,
that's an issue, right?
That's the problem. Like
she speaks to a reporter, and it was her as a witness, not
Yeah, so I don't rush to even with Tory Lanez, for example, when he was going in and out the courthouse, because he wasn't remanded, he spoke to me. I didn't speak to him. I'm like, he said, "I see what you're doing out there." I'm like, okay, I see what you're doing too.
I see it, but I'm not gonna say it.
Right. No, so I don't really try to engage with, I don't want to be that guy that they're now asking me to testify. Then I have to read them the the Rights Shield Act. Listen, I'm part of media. I can't be testifying, so I don't never want to be in that position. I was only in that position one time in over 30 years, but the judge erred on my side, so which was good. But yeah, the lawyers talking, and I think that the judge is probably going to grant the motion for the lawyers not to be communicating. Because they're messaging certain things. I'm not going to talk about any particular attorney, but certain things one of the attorneys said that I picked up on. I'm like, you probably shouldn't be saying that right now. And then while the jurors are not sequestered, they're looking at social media. Let's just be honest. The judge may have said that, but they're looking at it. I mean, how many people look at it? Do you look at your TV more or your phone more?
Phone.
Right.
Some people watch YouTube on their TV.
Right. So to think that these jurors are not understand what's happening, me personally, I think this case is over.
What's the flip side of that? How do you pick a new jury if you need to retry? If
take another 10 months, do another year.
No, it's costing the county too much money already.
Right.
Some lawyers want a mistrial, others don't want a mistrial. Like Mr. Stillwell doesn't want a mistrial, but other lawyers want a mistrial. So how's that going to work? So judge has to make some interesting decisions. Then she has to go back and look at a lot of the evidence. I don't see how this trial is going to move. I don't think this trial is going to move smoothly. And I
think that issue is a manifest necessity issue where it might be necessary to start from the beginning just because of the issue of catching up with the record. But that's not a reason that would warrant, because it's manifest. It's not a reason that would warrant that tagging on of jeopardy. So that's where you really run into an issue, because it's strong. 100%. The judge herself has said it would be impossible.
It would be impossible.
It would be impossible.
Bruce Harvey's motion, I loved it. So it was just so clearly laid out.
He's right.
How is this possible? How could you go back? You don't know.
And just logic.
Pure
logic.
It doesn't make sense. There's things that Glanville said he would readdress later, and now is later, and he's not here. How are you just going to come in and pick up from here? You can't.
While she said she said she's ready to go, but you're not really ready to go, because there's a lot of stuff you have to look at. You're not ready to go. When she said that in the courtroom, I said, Judge, are you sure about that? You're not really ready to go.
Yeah.
Didn't she say something about getting the transcripts from Weaver?
Yeah,
looking over it.
She said she's going to get it from Weaver.
You're gonna read all that. Yeah, exactly. Like
the judge made rulings that wasn't written. He made rulings that wasn't written. So you have to look at all those rulings. And when the prosecution stands up and says, "Listen, we're going to create a chart for you so you can see what the judge ruled," I'm like, okay, so I'm looking
now you got to trust your chart.
I'm looking at Brian still like, Brian, you're not buying that crap.
Right? No, exactly.
Do you see his reaction? Because you have one camera that is pointing to the judge. But when she said that. I'm looking
he tilts
Brian.
his head. His tail when he's listening, he goes
like him and Adams like huddling like, come on, really think we're gonna, and
Adams will look. Adams will go.
I love it. I love it.
But do you think that this case is over? Do you think these guys can still get a fair trial? Kat.
I mean, I really think that it could be a more likely of an acquittal, at least for a significant amount of the defendants. Maybe not on all counts for all the defendants, if it were to keep going, because I don't think this jury is tuned into the things that would make a strong case on the state side. No. They're just like, what is happening? Why am I here for so many days?
Right.
But I do think if it is a mistrial, I do think because of the size of this case, I would hope that it goes for no retrial.
Well, it should be with prejudice. It should be a mistrial with prejudice. I think that first
on constitutional grounds for the defendants, but also in the public interest. Both.
Yeah.
And you have an appeals attorney that works for the prosecution, so they have to look at the likelihood of this case getting overturned. So you want this guy to sit in jail for 4 years for it to manifest into a reversal, or you want to just get it done with? It's best to put this case behind you right now. It's touched 4 judges already. If you think about it, you had all these, I think about 4 judges. No, I don't want this. I don't want this. And if she really, I don't know if people knew, she was Judge Whitaker was in another division, and she came over to this division to take this case. But I don't know if she
was in appeal. She did appeals, right? Didn't she?
Yeah, she was in another division. She came over to do this case, but do she know what she's really signed up for? She wasn't in appeals, but I think I don't know if she was in family court, but she was in another division from what I'm told.
Some noticed that Love filed late Tuesday, was like, oh, this court previously was presiding over another issue with Young Thug's brother in a different matter.
Right.
But it said, it mentioned appellate in his appeal. It was part of his appeal, I think. So that's where I got that from. But I could be wrong. I'm just putting two dots together there and making a conclusion that might be incorrect.
Well, I think the 29th, I think the judge may make some rulings that was going to probably shock everyone. I think that's probably what's going to happen. I mean, look, she's looking at everything she has to sort out. Even the transcript.
Yeah.
Transcripts are not ready.
No.
And with Weaver, if she's doing other cases with Glanville, she's got to be working 9 to 5 or whatever his court hours are.
Yeah, well, he has a murder case. You know, he has a very big murder case that he's doing, the death penalty case.
Oh no.
So she's busy all day.
Right. So that the people don't know this, you know, while they see him at the YSL, he has this death penalty case that involved the Spar killing of Asians. That's his case. It's a death penalty case. So I mean, they see him in one courtroom, but this guy is multitasking. Plus, he's the chief judge who does the administrative stuff. So I don't know. You know, so I don't dog judges out because I may have to see him again. But
yeah,
I do.
That sounds rough for Weaver because guys, when they transcribe, they use a short code and then they have to convert it to the actual words and then put it in the proper formatting. So it's not just like it just takes the time for me to get these files together and put them in a drive and send them over. No, they have to kind of be transcoded, transcribed. I don't know the term for it. Translated from the short code that they use. It takes time.
Kat, you're an attorney, correct?
No.
Oh, you're not an attorney? Mel, you're not an
No.
attorney. Okay.
Not a lawyer.
I'm going to steal Mel's channel name. It's
He
going to
didn't
become
even ask
my
me.
tagline.
He didn't even ask me. He already know I'm not an attorney.
Well, I don't know.
He could tell by the
None of us
picture
are
behind it.
lawyers
Like,
here.
yeah, he ain't no attorney.
No, so how would you feel like, you know, you had to go behind someone and do cleanup? Like
Yeah.
you don't want to be that person that when it gets to the appeals court, they're like, wait, what happened?
It becomes
Right.
your issue if the
Right, your
appeals
issue.
court disagrees.
Right.
Yeah, so you don't want to be that person. So she has to look at all of that. She has to look at the it's just a lot to look at. It's so much to look at.
Yeah.
And, you know, while she jumped on the case, and I commend the other judges for stepping away from it. Judge Cross did what she had to do. I think she should have been a little more, you know, that's
She could have left a certain line out.
yeah. A certain that the line.
Leave it out.
Yeah, that line.
Leave it out.
That line. That line. That line to provide cover.
Yeah, exactly.
We saw what you did, Judge. We saw what you did.
Yeah, we saw that. Yeah, we
But
saw that. We peeped.
I was one who said that the judge wouldn't be recused. I didn't think that the judge would recuse her. I didn't think it was going to happen. Like you got to work with this guy. He's been here 28 years.
Yeah.
You know, he may sign you to a case, you know, division you don't want. You know, so
Yeah.
Well, and to be clear, that I'm asking a question here. You didn't think he was going to, but you felt like he needed to be.
It's kind of hard there. It did come across towards the middle of the trial. They was being very biased.
Mm-hmm.
You know, bias against bias for, you know, the exchange and the warning of Brian Still before he was going to. It was a couple of days earlier that he was going to say he was going to hold him in contempt, and then a couple of days later he held him in contempt.
Mm-hmm.
Sort of build up, and it was more aggressive towards Max Short, Brian Still, least aggressive towards Adams and Weinstein.
Yeah.
So you saw that, and then allowing the over talking, you know, when Brian had to step in and say, hey, listen, you know, I'm talking now. And the tension there between the two of them, it's so thick in the room.
I always wonder, because we're of course watching virtually, and I'm like, if it feels like this for me, how is it in this courtroom? Is it as intense as it feels or seems?
It's intense. You know, you have to think that they have to walk out, and Brian walks out to the doors to the left to the right of the courtroom. She walks out to the left, and then, you know, they have security. Each one of the prosecutors have assigned security everywhere they walk. So, you know, it's just, you can see the tension there, but you know, they they fighting for their clients, but this one seems pretty personal.
Yeah.
I mean, you start calling the judge, honorable
The
judge,
locate, lowercase.
Yeah, exactly.
Where's the honorable Weinstein and Judge Glanville? Like, wait.
With the lowercase.
With a
I
lowercase.
overcapitalized titles just to be proper and polite. And that was a lowercase judge all the way through that document every single time.
I said he was trying to burn down the house at the end. He was like, listen, you trying to put me in jail for 20 days? No. I'm throwing everything at you.
Yep.
And sure enough, he did.
Well, and Steele's trying to hang out in the cell with Thug, in the house if he's on house arrest. He's like, send me wherever I need to be.
Pretty noble considering what's going on in the jail. And the conditions. Like, you really trying to be there on the weekends. Like, you're not getting no special. You might get a peanut butter and jelly sandwich, but you're not getting nothing special there.
Yeah.
So I get it. But let's see how this thing plays out. Let's see how it plays out.
Tuesday is going to be amazing.
We'll get do you think a lot of these motions will become oral arguments? Because a lot of them did request a hearing.
I think that this judge will probably have oral arguments because I've covered it before. She'll probably allow oral arguments because these are some serious motions that have been filed.
Yeah.
You just can't result this to paper. We want to put it on record. You want to have the YouTube clips. You want to go viral.
Not for nothing, but there was a lot of stuff missing from both sides. I criticize the state a lot for it because it's consistent with them, but I feel like there's a lot of arguments, a lot of, the specific thing that you're actually taking a gripe with. What is it? Because you're linking to exhibits where you want us to watch a whole thing, and you need to make the argument in your motion what it is specifically and what's wrong with it.
Yeah.
Right? You're just saying, like, here's an exhibit and we want you to do this.
The judge, you can tell she's very efficient.
Mm-hmm.
And she wants to run an efficient courtroom. And she already signaled that this case is taking a long time. She's not going to let them drag out. Oh, you got 200 witnesses? Oh, no. Let's see. Make sure these witnesses are not going to say this cumulative witnesses. No, we're not. First it was 400. They cut it down to 200. No, maybe we can cut that down to 75. Maybe we should have this case over with by the end of the year.
Mm-hmm.
She controls the courtroom. And
now, would that updated witness list show up on what we're able to see in the records?
It should.
If they had turned it in, because I haven't seen that, and I thought that was also due on Tuesday.
I didn't see the updated, and I didn't get an email because I was the one who made asked the question about the witness being shown on camera because that was an issue. Bruce Harvey didn't want any witnesses excluded from camera. Some witnesses that were excluded, I did have an issue. Why, if you're not an undercover investigator or a detective, why you exclude certain witnesses? Because what we learned from the O.J. Simpson trial was that when, for example, Mark Furman testified, there were people coming out the woodwork saying, "Hey, this guy's a racist. This guy's saying, So you put stuff on the camera, and that way it'll bring people out to be able to at least give their position on how this person may be. So some of the law enforcement that was, I think it was one who was. Y'all remember the time that there was a black car. There were undercovers that pulled up to a resident, and they one of the, I don't know which witness it was. I mean, what defendant it was, but he brandished a firearm. They didn't get out the car and they left. Do you remember that early on when they went to the neighborhood?
That was the witness that didn't want to be
the witness
seen.
Right. But he's law enforcement. He's a lieutenant now, but you're not on undercover assignment. So why can't you get on camera? So again, the judge gave the prosecution a lot more than I thought they should have given them as far as shielding witnesses. Because first, and there was another time where you shield the witness on. You show the witness on Monday, but Tuesday you can't show the witness. What are you talking about?
Yeah.
We have them on camera already.
Yeah.
We have them on camera, so I understand that. So hopefully the judge, and I'm going to be one to speak up if I think there's a witness that should be shown. I'm going to ask. I'm going to say, listen, is this person? What's the reason why we can't show this person? Do it. Yeah,
and I do need to say I still think that this is much more transparency than we get from a lot of courtrooms that don't let cameras in, right? So I'm torn because on one hand, I live in Florida. We are so Sunshine State oriented, but I used to live in New York, which was it's pulling teeth to find out what's going on in a trial if it's not coming through a news reporter.
Right.
And I've watched plenty of trials where the news reporter selectively omits things from the transcripts that I think the public would be interested in looking at.
Yeah.
So
Always-
we have that advantage here in Georgia, especially watching this case on camera. But at the same time, if we look at Georgia in a bubble, if we know things can be televised, then what about this witness? What, like you said, is there a basis to actually hide this person, shield this person?
Well-
It's not a minor. It's not a juvenile. It's not someone that's under threat.
So you make a good point, and I'm thinking about the bigger picture. When cameras, like this case is being covered, highly being covered, no different than the Amber Heard Johnny Depp case is being covered. This case is different in that you got a judge who was recused. Do you think other judges are going to be cheering on cameras coming in their courtrooms around the country? You got a whole judge that just got to recuse a chief judge. Do you think these other judges want to be put under that type of scrutiny with a camera in the courtroom? I'm fighting to get cameras in the courtroom. They're trying to keep cameras out. You know, the Supreme Court, Judge Roberts is like, no, we don't. I want cameras in the federal courts. So I think this trial is going to make more judges apprehensive and allowing cameras in the courtroom. It's
There's an ongoing trial with that issue, and the judge was an advocate, was for her state. It was, I forget, the name is slipping me. It's a guy that's being charged for a double murder of 2 girls. It's in Midwest, Northwest somewhere. But now that judge doesn't want cameras in for this trial, and the defense has already filed motions about the judge's conduct and the rulings that she's made. But she was an advocate for the transparency, and now she's blocking it. And it's like, you raised your hand at the wrong time then, because now people are going to question why you're doing that. So if anyone wants to raise their hand and say, well, we don't really want cameras in the courtroom because we saw what happened to Judge Glanville. Well, is anyone really saying that Judge Glanville got recused because, he was done dirty, he was done wrong, there was absolutely no reason for it? Maybe we didn't expect it would rise to the level of a recusal. We didn't think that would be granted. But we can see why there could have been a basis for it to be argued. So if a judge says, I don't want the scrutiny Judge Glanville got, well, is there...
Yeah, let's hope judges... Well, there's right now, like New York, they need more cameras. Like, for example, you went through a whole trial for former President Trump. It should have been televised.
That's a public interest. Sure. The definition of public interest.
Yes.
100%.
And I fought to try to get a camera there.
Judges
don't know. You can take a still picture, but the still picture don't tell the story.
Yeah.
The court photos are kind of hilarious, though. The drawings, the artistic renditions.
Right. Yeah, but no, video, you want the transparency. And sometimes the defense don't want cameras in it because of, Stormy Daniels to testify. Like, why is she even testifying in a case that involves records?
Right.
It shows in black and white that money was sent, it was paid. So again, sometimes the defense don't want cameras in, and I get it. I really do.
Yeah, so joint stipulation, but those courts just don't. It's like the cameras aren't really a thing anyway. So other courts, it's like it's going to be televised, it's going to be streamed at least. It might not be popular and on law and crime, but if someone wants access, we're not going to fight it unless the parties motion for us to fight it.
Right.
So, and Georgia's in that situation where it's, cameras are pretty open. Same thing with Florida. Our tech lacks, a lot of the streams are you have to get your Zoom code and tune in, and then when it's done unless you're archiving it because it's a high profile case. But
I had a judge in Fulton County, both the plaintiff and the defendant didn't want cameras in the courtroom. The judge, he said no. We're gonna, he did everything right. We're gonna bring the cameras in the courtroom. So sometimes the judge can make the call himself and say, "Nah, we want cameras in the courtroom." When both of them don't want it in the courtroom, that's hey.
Hold on, let us settle this then. Let us hurry up. Let us mediate. Give us another chance.
Ex parte courtrooms is what we're having now.
Right.
None of us want our stuff aired out.
Yeah, the ex parte was bad. It was bad.
I think there would have been reconsiderations knowing the outcome of the Depp v. Heard trial. There may have been stronger opposition to what could have been on camera.
Right.
There were some protective orders in place, but it was actually Amber Heard's own defense attorney that in her opening statement spoke about something that was supposed to be kept under seal. We weren't supposed to see her testify about the bottle incident in Australia.
That's right.
So that's as much as I'm going to say about it, if you guys know what I'm talking about. Right. But it was her own attorney that opened that door during opening statements for that to come in. But otherwise, they didn't really fight
that was set on
against
camera
the cameras. Yeah.
Never said on camera, right? So sometimes they try to slip things in, to get an advantage, a public advantage, So
And then it backfired. You can't change your mind. So
but I do think that the lawyer speaking in this particular case probably should have, and it's almost like you thumbing your nose at firstly, you're making claims about certain things that the prosecution's done. They're not speaking at all. Only one spoke about the case was Fonnie Willis, and that's she talked about it during the
indictment era,
right? But they're not speaking. So is the judge gonna say, okay, since you want to speak, we're gonna let them speak? Do you want that to really happen? No, you don't want to fight your case that way. You don't. And at the end of the day, if this case is a mistrial and without prejudice, then you got to find some new jurors, and their lawyers already spoken. So I don't see this case. If it gets a mistrial, how are you going to move forward with getting impartial jurors?
Right.
Yep.
And look how long it took to get these jurors. I don't think Judge Glanville took a long time to do it, but
Yeah, like 10 months, right?
Yeah, 10 months.
Well, now they'll have extra barriers, even if with an efficient judge. But I still think that motion should have specified what crossed the line, and this is the limited scope of the limitation that we want. You can't just ask for a broad stroke gag order, especially for a trial that could go on for many more months if it continues. It has to be some type of balance.
But you could tell the lawyers, you can't speak about the case. Fight your case on, if you want to speak about the case, speak it in your motions and let us do the interpretation and bring it, other attorneys in to talk about it, but the lawyers shouldn't be talking about the case, in my opinion, right now, while they're fighting the case. Especially if it goes to bashing the judge. One lawyer may say, hey, I don't like the judge, and then now you got the
other
judge,
defendants could be bothered by it,
right? And then you piss the judge. You piss the judge off. You got 6 defendants. You piss the judge off for one. Again, you're going to see how this judge moves.
I'm looking forward to that argument. I still think, the argument will have to be made what specifically it was that didn't fall under what attorneys are allowed to talk about in public.
25.1, the rule, I think she cited 25.1.
I have it open.
Yeah.
But those bullet points, I think some statements about the ex parte meeting fall within that realm. But that doesn't mean that conversation didn't go off the rails somewhere and one of the attorneys said something too specific or too hot of a connotation behind it. But I didn't catch it personally. And that's why I think it should have been specified. It should have been quoted as part of the argument.
Absolutely.
And again, this order, we're not trying to stop you from speaking on these things that you're allowed to speak on, but we're trying to stop you from speaking on things that don't fit that bill. And I think that's a stronger ask to a judge, because I don't like when any judge plays lightly with access to press or public access to the trial or the defendant's right to have a public trial. So if the press seems to want public trial, we want answers. Well, the defendants seem to be fine.
We have cameras here. Now, if there was no cameras allowed in the courtroom, then
there's an extra reason to.
Yeah, we're trying to get some sound bites. Like when Cardi had her case against the blogger, there's no cameras. So I wanted to get the lawyers to talk, but they wouldn't talk. It was a high stakes trial. They wouldn't talk. I wanted to get some kind of sound bite, but they didn't want to talk. So I understand, but if there's no cameras in it, how else is the public going to know what's really happening? Rather than we come out like I was doing and giving a blow by blow of what was happening. But nothing like having cameras to keep people honest.
Yeah. Wait, I just have to say, because I was Exhibit F in that motion, because I
right.
I was Exhibit F. I interviewed Doug Weinstein. We was quoted. But so anyway, all of that to say, I am very interested in how this is going to go, because I think what you're saying, Dennis, obviously is a good point, but I also am a fan of, hey, let's have these conversations. So I get it, and I'm very interested, obviously, and invested in what happens and what the judge says.
But Mel, you didn't do anything. I saw your interview. I thought it was brilliant.
Me too.
Excellent job. And again,
let me pull up that exact video.
Yeah, all you did was talk about what we all saw, and you just got extra information for educational purposes about certain words and things of that nature, legal terms and stuff like that. But what you was asking and him speaking, like, it was just what we were all thinking and looking at anyway. So to say don't do that is like saying, but I can't talk at all about, I can't say my client is innocent. That's talking about the case.
Yeah.
You know, I mean, you know, like how linear are we going to go with this? You know,
Right. They're all presumed innocent. So
yeah. So exactly. So
Mel, how did
I
you
could
feel
talk.
when you saw your name in the
Yeah.
docket? Like filed
Listen,
in
I was freaking out. I was like, I am not a lawyer and don't want to be involved in this except in the way that I do it. Like, I don't want to be exhibits. But I was, you know, I'm like, oh, it's motion day. Let me, you know, log on. So I was reading through the motions and kept getting text and notifications being like exhibit F. And I was like, what are you talking about? So to see my name was, or to see our interview was, you know, I was taken back a little bit.
Now you have a subline. You could be hashtag exhibit F.
Absolutely.
I was published in the court documents of the YSL trial.
It's not what I expected to happen. But I mean, to the point, it is a little bit sobering on one end of like, make sure, right? Like these are the things, the conversations that you want to be and should be having, because this is real. These are people's lives. Like this is a real trial that has real consequences. So it is a little bit sobering on that, you know, because we cover these things and talk about them, but they have real consequences. But on the other end, I guess it really did, in that same checking is like, well, how do you feel about this? Do you feel like you should have done that? Or do you feel like, no, you fight for, and you stand on kind of what you did? So yeah, it was just very sobering for me.
It was educational. And I think when the lawyers educating the public as to different things that are happening in the courtroom, I think that part is very important, you know, because people are looking at this trial and looking at their situations in their respective cities and states and like, wait a minute, this could happen to me. Yeah. So what can you do? And the great thing about it being televised is that so many people are learning so much about this process, about the Constitution, about the Bill of Rights, about you know, freedom of speech, freedom of press. You know, so that's the beauty in it. And it's so great that YouTubers are able to bring in guests that can further push the conversation, knowing their rights.
Yeah. How many people literally knew what an ex parte was before this? You know, like
exactly.
People would have never known. I had no idea what that meant until this. And now we
secret meeting. A secret meeting.
Yeah, we are all informed.
And it's usually like something quick administrative, but for it to become something like bombshell or something that's called out is where it becomes relevant. Yeah. Otherwise, you can usually just skip over it. Like, hey, we learned that in this ex parte meeting that this happened. Well, the issue wasn't the ex parte communication. We're just addressing something that was disclosed because of the communication, which was properly disclosed to us. We want to talk about that thing that happened to be disclosed. So the issue wasn't really how it got to us, because it did get to us. But the issue is this material substantive matter. But yeah. So not all meetings are off limits, but this was a little bit extra.
At the critical stage of a case, you want to have a secret meeting. Yeah, you know, that's kind of.
Here's the problem I have. How many times did they have these meetings? Because there were times we were waiting in the hallway. These lawyers will tell you they wait in the hallway for 2 and 3 hours. What's going on? Where's the judge at? They didn't know that the doors are locked. We don't know what's going on in the courtroom.
Yeah.
There's been plenty of times where the course it didn't start until like after like 12 or after 11 o'clock, you know, and they were there at like 8 o'clock and 8:30 in the morning already. So yeah, I mean, even people like, even when I was watching like Law and Crime, just catching up with it, and you'll see people in the chat like, where's the judge? Where's everybody? And they're waiting on hours and hours just like everybody else. And it's like, okay, so maybe that was an ex parte day that we didn't know about. How about we investigate that? You know what I'm saying? So, and how many days and times did that happen? You know, so all of that got to be investigated as well to get to have it fully fair. You know, I'm pretty sure there was more than one ex parte meeting,
because this was done so smoothly. Like, wait a minute,
too smooth.
Like,
they just said, all right, let's go. Nothing happened.
Right. What the heck are you talking about?
Yeah.
Brian still runs. Like, excuse me, wait a minute.
Right.
But I think Doug was very fair. He did give the suggestion. I think it might have been one of his Twitter spaces where he does he defers to one of his law partners if it's related to what's going on in YSL. He did mention
Attorney App. That's his law partner.
No, it's
an
S. All right, so Mel's on the research, but Doug Weinstein had mentioned, look, some of the times, to be fair, when it did start late, it was because the sheriffs, they were having trouble getting all the defendants, the 6 co-defendants into the courtroom, getting them over from, where
Right.
they're being held in custody. So he was fair. He's like, not all those, like, it's not a full suspicion every single day. There could be reasons why we start late. Even if Judge Whitaker wants to start at 8:45, if we don't start on time, it could be because we're getting the defendants in the courtroom. So
And
well, that was good because we run with conspiracies on YouTube sometimes. Like, they're late, they're having another meeting. Maybe not.
Well, here's the problem we're going to have. The building opens at 8:30. It doesn't open at 8 o'clock. So you got to go through security. There's a long line of security.
So 8:45.
Yeah, so Judge said 8:40. I said, Judge, first of all, you got equipment. You have people bringing in folders and so much stuff. So much is happening in the morning. So I don't know if that 8:45 is realistic. I think she just wants them in the building, but I don't think she's going to start at 8:45 because, the court opens at 8:30. So I don't know if that's
the long crime stream is just going to be focused on her sitting there instead of the seal. She's just going to be sitting there waiting.
I don't know how to pronounce that attorney's first name, but it's Jimenez. I think it's his last name. It was he was representing one of the clients initially in this case.
Oh, yes.
Initially, right.
With the ponytail, Jimenez. Yeah. So I didn't know they were partners.
I don't know.
Shada. Okay. Is it just Shada? I feel like he says it different than Shada. It looks like Shada to me.
I know. I didn't.
Guys, I'm just gonna link in the chat to one of Doug Weinstein's spaces.
Oh yeah.
They both host it.
Mm-hmm.
Shada. I don't know. It sounds kind of right, but then I'm questioning myself. Shada Jimenez. So there's that though. But yeah, he did give that bone. He said, look, it's not always the judge's fault.
Right.
We can't, there's a lot of times where we can't get, because all of the defendants need to be present before the trial can start for the day. And if one of them, we have issues, because they're not all being held in the same facility even, right? Aren't some in...
No, well, Doug is in, he's in Cobb County, and I think the other defendants, another defendant's in South Georgia.
Oh, wow.
So they got to pull them from different places. They're not all...
So any one bad accident and this person's in en route, there's 3 ways that it could get messed up.
Yeah, so
ThuggerDaily says the Shada Jimenez. He says it with a little accent. That's why.
See, that's why I went.
ThuggerDaily.
So you can hear him. You can watch the space and hear how Doug Weinstein pronounces it. Mm-hmm. And his voice is really easy to listen to, Mr. Jimenez. I like hearing him talk. Very, very easy to understand the concepts he breaks down.
I think his client was Blaylock. Wasn't his client Blaylock?
Oh, maybe.
I think so.
It was someone. Were they severed? They were severed.
They were severed defendants. Yeah.
Case.
Right.
I mean,
he ended up getting I want to say a life sentence. One of the.
Oh, you're right. Yes. Yep,
right.
You're right.
For a different issue, right?
Different issue.
Yep.
Yeah.
And I was in Judge Adams because I stepped in that courtroom and I saw the end part of the trial. So yeah, he blew trial on that one.
Mm.
Well, let's what do you guys have coming up as far? Well, Dennis, let's start with you because you might have 2 platforms. Are you doing anything on YouTube? But also, should we expect some thread on some coverage anytime soon over on X?
We will. I'm sorry, I just got a message.
That's okay.
I'll be covering YSL, but I'm also I don't want to say the trial until I kind of just wait. I don't have everyone run into the courtroom. Like I won't tip my create more competition for my coverage on that trial. I'll let you guys know when I tweet it out. Like for example, no one knew Tiana Taylor was in court until the day I tweeted out. So I kind of don't tip too much to the social media until I'm actually in the trial.
Yeah, aside from you, I think I only saw wardrobe. Someone covered an outfit that she wore. I think she was wearing super huge sunglasses, and that was the only other coverage I really saw on my own feed besides from you. Oh, so then it was from you being shared.
All those pictures were yours.
Yeah, I shot the picture.
No, you it definitely got stolen though, because I swear I saw it on one of those Pop Crave or I was they're talking about her trial.
Yeah.
Then it was just a photo. They didn't go into the details you're covering.
I went to go get that check. I didn't know.
It was Pop Crave, one of those little stan culture magnets on X.
She was fashioned out. I mean, Gucci, Prada, she had the styles. So did Iman, but he came through the other door. So they never walked in the same door from the street.
Dang, we missed the other half of the fashion.
Yeah, he was.
You could start a side thing just covering courtroom fashion. And do an affiliate to like link. Maybe, I don't think Gucci has an affiliate program, but some other things. You can monetize your YouTube. Yeah. This is the outfit. This is the shoes that they wore.
I would expect nothing less from Tiana. Nothing less. She's a fashion icon.
Yeah. Tay Biz, I know you're doing Lil Boosie. What else you got going on?
Yeah, I'm covering Lil Boosie today live at 7:30. Very, very interested in this reindictment that's going on with him. I actually got the documents and the court filings and things like that. I actually perused it, and it's very interesting the way they're trying to paint this. So I do have
primary source material, you guys.
Yeah, and I'm also thinking about I'm also thinking about doing the Sonia Massey situation.
Yeah.
I think that's very,
that
very,
case.
very
I'll probably
important.
be covering that case.
Did you see that they asked for cameras and they said no? It was denied.
I did not know that.
Yeah,
wow.
I got the indictment, and in there it is the request, and the judge denied it.
Oh, wow. So I have a problem with that already.
Yep.
Yeah, that's already an issue.
We have a body cam. We have body cam footage.
Yeah.
That's the extended version, and you don't want this child covered. Oh no, we have to cover this.
Yeah.
We have to be in the
and that's why that hearing from last week. That's why it was nothing in there. There were no cameras. There's no footage. There's no cameras in there.
That's crazy.
So I'm not saying cover up, but I don't like that. We had
the defendant is someone that's supposed to act in the interest of the public. It's not just an individual. He wasn't. This didn't happen while he was acting in his individual capacity as a regular citizen. This happened while he was supposed to be protecting the public. So transparency would be more warranted than necessary, I would argue. I don't know the state's laws in general about cameras in courtroom, but this seems like a reason to lean towards granting it.
Well, in Illinois, we covered R. Kelly, his arraignment. We had cameras in the courtroom. So this is interesting that they don't want it in Springfield. That's pretty interesting. We need to look into that because this is of national attention and importance. So
and they want us to believe in the judicial system by not showing this. It's already a high level of tension when it comes to this particular case in the first place. So
and
the more transparency, the better. Actually, in this instance,
missing one of the body cams, it starts after. So we have another vantage point, but Dennis Byron was touching on that already. Like, we have a body cam, but not exactly, because the guys turned into the garage while you can hear the voice of the other officer raising his voice, like, you better not. So we're missing what could have been on his body cam because he did not have his body cam on.
He didn't have it on. And I want to, and then you see how they said turn the body cams off. You saw when the video came to an end, turn the body cam off. Why'd you turn your body cam off then? You're still on the crime scene.
Right, exactly.
You're still on it. We saw detective, the detective in Atlanta, when he was giving testimony, detective was on the court first 48 show. You guys know the detective, the old OG detective, light-skinned brother with glasses. Mr. I know,
Don't ever ask me for names if it's not on a piece of paper that I'm reading.
Probably say it.
But they recorded the crime scene. They were, they had footage.
Quinn.
Thank
Love you guys.
Quinn. So
good looking out, Chad. Good looking out, Chad.
Detective Quinn. They had footage of them on the crime scene. So why are you guys? And the other problem I have in this particular case, why didn't the sergeant take his gun and tell him get out the room? They let him walk the crime scene. One thing I also noticed is it was the other cop. He paused in his car for a while and he was shaking. His hands was shaking and everything. Did you see that part? Where the cop was shaking, his hands was shaking. So it's an extended version of the video that I saw where he was basically wiping the blood off his hands and shaking, and he was, he was pretty despondent. This happened, and he was trying to administer first aid. And the guy was basically let her, almost like
No, it was a headshot. It's no point,
No
or whatever
point.
he said.
But she's still
Gasping.
So this is a hard case to watch. That you watch the video.
Yeah.
Yeah, I think a lot of that's crazy, and it's again, it goes to why we need transparency. When I was looking at the Jonathan Majors case, they didn't allow any of the audio from the body cams to come in, which was hugely problematic to me because they also wouldn't let lines of questioning come in when Grace Jabari was on the stand for what could have been said.
That's right.
And cool, we can't see the source material recording ourselves, but we also can't ask the witness about it, about what was being said, when it seems like from the line of questioning, she had told the officers, in utterance, if you will, that this happened at a totally different part of the night where she sustained her injuries. So the jury ends up acquitting on these intentional charges, sticks with the reckless because they're not instructed on justification in New York. So that's reversible error. I'm sure the appeal will argue that. But a lot of the jury confusion could have been figured out if they were able to hear the body cam where Grace Jabari may have said, hey, the state's whole theory that my finger broke in the cab, that's not actually when it happened. I told the cops it happened 10 minutes later when I started attacking him again. And they don't let the audio come in and they don't let her get questioned on it. And there's no cameras in that courtroom for us to see that play out.
Right. We saw the body cam while running after him, but let's put everything in context. Like, so he was trying to protect you from not getting hit by traffic. And you run in, I don't know if you live in New York, but you run in Manhattan at that time in the morning.
Well, she almost got hit by the one car in the video.
You're right.
Yeah, that
and it's like, not to minimize that, but those are two private. I mean, there's celebrity in a way. He's a celebrity, but still in that night, for all anyone knew, just citizens out here, something happening. But this is a cop, and we're not letting this evidence come in.
Right.
I really think the admissibility could have been to protect the police officers who ended up charging Jonathan Majors with strangulation where there was no evidence of that ever.
Right.
So I really think that admissibility issue wasn't just some weird bone to throw at a witness to help them out. I think it was to help the police officers and protect the NYPD. But in what we're seeing here with Sonia Massey, same thing. We're missing the body cam, and now you don't want us to see the demeanor, if the guy takes a stand to testify. I mean, he's going to have to say he feared for his life. How else are you going to get that evidence on record if he doesn't take the stand? But with no cameras in the courtroom, we will not get to see this officer's testimony.
It's insane.
I'm sorry.
Dennis is going to be out here fighting this weekend. He's going to be like, what's going on with this new order?
Yeah.
That was great that you'd already seen that, Mel, too. Like,
I hit the clerk up last week, like, hey, I want to see this because I was seeing some conflicting reports. It was before the body cam came out, and I had been seeing conflicting reports, and I wanted to see the actual petition from the prosecutors where they kind of detailed what happened. And as I was reading, I said, hold on, wait a minute. What's this?
I need to look into that because this case is going to, and a lot of people this is a big case. People around the world want to know what
exactly.
We in the political season. Why are you not trying to protect? Only one can benefit from the cameras is the cop.
Yeah.
Yep.
100%.
Yeah. Oh, for sure.
That's the only one can benefit from not having cameras in the courtroom. Like, no, the public needs to know. You say you have all these medical issues, in your bond motion, but now you're asking your attorney that, listen, I don't want cameras in this. You're embarrassed now. You had 6 jobs. Like, what 6 jobs in 4 years?
Let's talk about it.
What are you doing with 6 jobs in 4 years? Any police department that hired them after the second job should have asked.
Has a liability question on the table.
There's more there. We just don't know what it is.
Yeah.
Do you guys think that the other cops should be charged for drawing his gun, or because he drew his gun while the other one fired the pistol? Both cops drew their gun.
I think my testimony or seeing a statement from him could tilt my scale on that a little bit more. Maybe there's a gray area for that me right now. What do you guys think? Because he didn't shoot, right?
He didn't shoot.
He didn't shoot.
No,
but he also had line of vision to see whether or not there was a threat there. You didn't see him try to talk down his partner. And then the other part is, why are you cussing at the lady? She's actually handing her a Bible, but are you cussing at her? You're cursing her in her home. Like,
Yeah, I
And
think the
outside
interaction leading up to everything was weird
was just
too. They
weird.
It
didn't
was totally
understand. She was
weird.
trying to get her license for them. I have
Yeah.
documents for you. I don't want your documents. Okay, well, what's your name? Well, I'm trying to get my documents for you. Well, do you just have an ID? Well, just like understand that that's what she could be looking for in her purse right now. And you
Right.
could
They
tell in
shouldn't have
that
been in
moment
there.
she looked at them like,
They shouldn't have
okay,
been in
I'm
there
gonna get the
anyway.
thing I was trying to get.
Well, I was gonna say I had a conversation with a retared trooper yesterday. Actually, it'll be on the debrief. But he was saying they actually shouldn't have come in.
That's what I'm
Frankly,
saying.
should have
Yeah.
actually.
She said that she was okay at the door.
Yeah, and the prowler would
So,
indicate that it is someone on the outside of the house, and if she is
right.
walking around her house, they actually had no reason. She was never under arrest, and they actually should have never come in her house. And
Nope.
so
Right.
when you put it into
They-
that context,
Yeah, they shift from investigating a possible a victim, witness maybe. Now you got camera, flashlights going through a bedroom, and you're asking these questions. Once you realize that there was no issue, now you're asking about the car in the driveway, and
right.
and you know, no, we done with that part. Now let's investigate what else is going on here. Then before you get to the
Let's find
inside the
something
house,
else.
you're already
Mhm.
make the hide the drugs. Like you're saying stuff like this on body cam. Hide the drugs. Search warrant. You know you didn't have a search warrant, but
Right.
so you know this was definitely, the cop was definitely unprofessional. Definitely
Yeah.
unprofessional.
From
And
the
then
beginning.
then he shouts, "Open the damn or don't have us waiting," or something like that. You know,
Yeah.
you know, it was just rude.
Yeah,
Do you go in everyone's neighborhood
It's
and
out
do
of
that? Yeah, it's out of
and
pocket.
this is why all of it should be television. We should all be able to watch
We
it.
all need to see this, especially this case.
Yeah.
And
Especially this
to me,
case.
the beginning doesn't show someone that was in fear that their job puts them at risk. If that was the case, a reasonable person wouldn't be approaching the doorway this way. They wouldn't be speaking through the door this way. They wouldn't be
Right.
maneuvering that way to try to give an attitude to someone that they feel like is threatening to them.
Mm.
Like because that's reasonableness is going to be the question. Would a reasonable person act that way in the same scenario? And we all like just that's unreasonable like from the start. Before
If you
anyone had any
are-
boiling water in the picture.
That's what I'm saying. If you're a police officer and your life is threatened off of boiling water, you shouldn't be a police officer. You should just go home and do something else. There is no way in the world. I'm getting a little bit passionate right now. I'm sorry, but there's no way in the world that you're talking about she needs to stop boiling her water. For what? That's her house. That's first of all. You ain't even supposed to be in there. That's number one.
Right.
Why are you even in there? So when she came to the door after you banged on it like a maniac, she came to the door and said, okay, I'm fine. I'm fine inside. I'm thinking somebody lurking around my house. Y'all checked it? Okay, fine. You didn't find nobody? Okay, I'm good. Why did you step into my house in the first place?
Right. How did it
I'm
go
sitting
from,
there.
right.
And then she never got off the phone with whoever she was on the phone with. She stayed on that phone. She knew. She felt uncomfortable
Smart.
by them. They escalated the situation. Police officers are supposed to de-escalate situations.
100%.
So this whole entire situation, it has a lot of tension in it, and I'm not going to go into the whole race thing and all that kind of stuff. But you best believe that they're
Are you
going
gonna
to
go into
start.
it?
They're going to start talking about this. I mean, this is a bad problem. This is a situation. And speaking from somebody who's been through the law situations before, I've been on probation before. I know how plea deals work. I know how all this stuff goes. They're looking for a reason to do this, to make this okay. And we need to fight for this and say, no, this is not okay. So I'm glad that you're feeling a certain way, Mr. Bryan, about getting this televised and all the kind of stuff, because we need to see this. We need to see this man's face. I want to see him say he feared for his life and mean it.
Yeah, me too.
So I can slap him. Okay. So I can slap him upside his face.
We gonna start a fund
Yeah,
for your
real talk.
your monitor replacement.
Yeah, real
Right,
talk.
No,
Well,
so
and
So, for real.
it has to be
Yeah.
televised.
Mhm.
So here's the other problem. This can turn into a protest, a riots, and so
Oh,
forth.
for sure, absolutely.
Because what are you hiding? That's the first thing people want to say. What are you really hiding at this point? Who benefit does it serve by not having cameras in the courtroom? So maybe they have to get another judge. You know, listen, that doesn't make any sense. I thought a case like this would be televised. We saw the people who killed Ahmaud Arbery. Their case was televised in state court.
Yep.
And it was a heinous act, but it was televised and it served public interest. So not a judge not wanting to do that signals to me that they're trying to protect their own. And we did see
Well,
that.
and
We saw
it's interesting because we get the body cam release like kind of quick compared to other, body cam releases. It was like what, like 12 days was the difference or something like that. It was less than 2 weeks, I think. But that's not the court deciding to release that. This decision is coming from the tribunal, from the court saying, look, we're not going to televise this trial. So it's weird because we actually have some transparency and a willingness to charge pretty quickly from the DA's office. And then the court's just like, we're not going to let you see more.
If you look at the body cam footage, I saw a July 6th date on it. I also heard a lot of fireworks. So why is all the fireworks July 6th? 4th of July is the 4th. But you heard a lot of fireworks. What was going on in that neighborhood?
Because that was Saturday. So, because July 4th was on a weekday, that I was thinking the same thing, but I went and looked at the dates. But you know how like people will do the bumper weekends? They'll celebrate either before or after an event. So Saturday's probably people firing off their July 4th stuff, having their barbecues.
Because we had it on the 4th and that was it. We don't want to hear no more the day after.
Listen, I only know because I'm in Florida and I still hear fireworks at night right now. So like, we do not stop.
Are they fireworks or drive-bys?
I have that question once in a while. But really for like July 1st through that Sunday, so the 7th, tons of fireworks at night as soon as like 9 o'clock rolled around. 4th had the most, of course, but a lot of fireworks all through the week. So that was my thought. Like the 6th, there's just people firing off what they've got. Didn't want to spend the barbecue money on Thursday. They want to do it on Saturday and people can come hang out. And there you go. So I don't think the date's that weird. I think the date's accurate. It's just
okay. It was like 1 something in the morning.
Mm-hmm.
Yeah, that doesn't matter. It happens here. It's like, oh my gosh. Well, that'll be good. Look, you guys we've got a bunch of people that want eyes on this case. I have seen a lot of interest also on X. I'm sure a lot of people will push back once they hear. I haven't heard people mention that was denied. Cameras in the courtroom. But we can all go raise some hell and stomp around about it.
Yeah, I was going to say,
we will. Don't worry, we will.
As it continues, maybe that'll change, but that was the latest in the.
It should have happened at the bond hearing. It should have had every stage of the process, the pre-trial, every stage. It should have been cameras in there, and that's signaling to me that this judge has made a determination that the public don't have the right to see all the proceedings.
Yeah,
see,
that's not good.
So we got to have the candidates. Well, one candidate. I don't know if the other one's going to say anything, but. Speak about having coverage.
Yeah.
Like the chat, we've got fireworks out here. Atlanta's the same way. Fireworks last night.
Wow. Was that fireworks or drive-bys? I'm like, what the heck?
No, I'm telling you, we get fireworks like still. Even for like Memorial Day, any holiday that warrants a barbecue, because it's warm all the time in Florida. Any holiday that people are outside, fireworks are going to be involved. Even Thanksgiving, sometimes people will go out maybe after dinner and you see like some of the like lighter fireworks. Our fireworks stores are open not 24/7, but all year round. It's a great time for my sleep schedule.
Different place.
I think we've got some homework, guys. If you guys, no matter what you think about the facts, if you want to see the facts of a trial, transparency, I think is always good. I think if you watch my channel, you're probably a fan of transparency because it's kind of what we always talk about here. We've got all the panelists, and Ghost and Drea have been holding it down, dropping the links to all of their channels. I know we've dropped Dennis Byron's X account. Real quick, verbally, you said you got to start using X, but do you have a handle name over there, Mel?
Yes, You've Got Mel was my original before I started.
That's cute.
You've Got Mel, YOUGT. There's no O in got, and then MEL. So that is my X handle. And then
why don't you have? I'm not a lawyer. It's your X handle. I'm not. Is
it Pagan?
Because X freaks me out. It's because that place can be.
It is a lot.
And so because of that, one of my videos went viral on there once, and I said, never again. Y'all won't catch me slipping. Nope. And so
what happened?
I want it.
Hold on, don't make us look. We're curious.
But it freaks me out. So You've Got Mel is my name on X, but I'm not a lawyer. But everywhere else, And I just wanted to say, because you were asking some things that are coming up, and the Alexis Crawford case that is in Fulton County in Atlanta, which is the college student from, I think it was 19, who she had a roommate, and the roommate and the roommate's boyfriend are charged with her murder.
I remember that.
Atlanta girl. And I went to Spelman, so that is a case I've been following. And I just saw the motion filed by Fani Willis on that to ask for the court date. They are asking for an August date. So I've been keeping my eyes peeled for that to come up, because once that happens, my channel will be all about covering that case. It's supposed to be 2 weeks is what they are saying, how long it'll last. So
what judge assigned to it? Do you have a judge assigned to it?
Yes, it's what's her name? It's a Black woman judge. Give me 2 seconds because I'll tell you.
Williams, Judge Williams.
What's her first name? Is there a Brenda?
Belinda Edwards?
Belinda.
Belinda, Judge Edwards.
Yes, that's it.
Oh,
that's cool. That's who's going to cover that one.
Okay.
So, guys, Belinda Edwards is the one that recused herself sua sponte from hearing the recusal.
Yeah, exactly.
She got up out of there. So she said, nope, this is
she was
fine.
good with it. She said, I don't want to touch none of this.
So that one for sure is coming up. One of the cases that I covered originally that got me massive on TikTok was the YNW Melly case. So I am still following that one. I recapped that whole one during that trial. So keeping up with
content through 2025 if you follow Mel. Me, I could retire after I might be like, I don't want to do YouTube anymore, but she's in for the long haul. She's getting stuck like Nick Starro got stuck with this YSL trial.
So I have a question for you, Kat. This YSL is a pretty big case. What are you going to do if another very big case comes to the forefront? Like, there are cases that are coming to the forefront. Will you drop YSL, or are you going to multitask? Are you going to do the, so how so
I think if I see a void in something that's not being talked about, and a great example right now is Sean Williams. He's actually facing 2 trials, and right now it's a trial because he tried to escape from prison, and then he successfully escaped from a van while in transport to a hearing. And he's representing himself pro se. It's federal, so you can only read about it.
Right.
No cameras in the courtroom, but still. But his whole story, it stems back from 2018. People started raising awareness about him in Johnson City. Some businessman, sketchy business, people falling out of his windows. They're drugged, they're incapacitated. They're going to the hospital to report that they think that they may have been assaulted. And then one of the police detectives, those police reports, the SANE test, they're not testing for any drugs in the system. Mm-hmm. So there's allegations of police corruption. And in the last month, they've introduced into evidence bank records of $2,000 payments going back and forth between certain parties that are alleged to be at the heart of this extortion scheme. So right now his trial is ongoing for the escape issues. And later in the year, he's supposed to be on trial he's being charged with having alleged over 50 victims. And they know this because he had 2 thumb drives that had photos and videos of these people in his apartment visibly unconscious, including children. And very few people have heard about this case. So I wanted to start talking about it because it's insane to me. There's been people that have really been advocating, reporters talking about it. It's not like people are turning a blind eye, but it has not had that kind of outcry attention just yet. And I think it deserves it.
Do any of your panelists have an interest in actually covering cases from inside the courtroom? First, Mel.
Yeah, I'm in LA and I'm planning to do ASAP. I went to ASAP's hearing in January, ASAP Rocky. I'm doing my paperwork early to get my Rule 22 so that I can be there. So that is the first one that I am planning to be in the courtroom for.
Well, I have a contact there, so.
Okay.
Yeah.
Well, I'll contact you to contact your contact.
Yeah.
Dennis needs to put together like a Rule 22 course. Like, here's how you do it. Here's how to figure out who to contact.
Well, Rule 22 is only in Georgia, so every different, like LA.
Well, the equivalent.
The equivalent, but yeah, you have to, especially in LA. And the other thing is, you're going to want to get some of the evidence And so that's a
Yes.
different process, and that you're going to have to pay for, some of the, you have to
Yes.
pay for that. But yeah, that's going to be a big case.
You got to give me the crash course.
Yeah, it's going to be a big case, a very big case, especially.
I'll help crowdfund for documents and stuff.
Yeah.
That's awesome. I also have a Patreon, and I use a lot of and I put everything in my Patreon. So if you're in there, you get every document I get. I put it in there. I just got the one from Keefe D, the Tupac one. I got that whole. So everything.
That's another case. Oh my goodness.
Yeah.
That web portal's annoying. That's also an Odyssey portal, right?
You're close.
Yeah.
4 hours away. You got to cover that.
I know. So that I'm thinking about it. I saw the court date for that is.
That's
November
a big case.
4th.
That's a huge case.
It's November 4th, and I can write it off if I go. So I'm thinking
Yeah, that's a big case. That's a court case.
That'll be good.
Yeah, that's
I need the crash course so I can be there.
Yeah, definitely. And there's cameras in the courtroom, so
yep.
So we don't know what Keefe is going to really say. We don't know who's going to be called.
No.
Did you get is the witness list out yet?
I didn't see that in there.
Discovery.
I didn't see. I was in there kind of cruising around yesterday just so that I could get that document that everybody's been talking about, the whole Diddy thing, and I got the whole transcript. So I have to peruse around a little bit. I didn't see a witness list though at all.
Okay. Interesting.
That's awesome.
Well, what would be the
legwork.
biggest case that would take you off of YSL? Diddy?
Yes.
Diddy? Kat? Diddy?
Listen, I'd rather be in someone else's chat watching it, so I'll probably go over to watch it on Mel. Because I know it'd be too much of a commitment.
Yeah.
To stack back to back. I
That's gonna be a
already
long
know,
case.
so I wouldn't want to start and drop it off.
Yeah.
Situation. Yeah.
Yeah, I would literally have to stay in New York for that one. If it goes down in New York, I would have to stay in New York. But there's no cameras, so it's fed. So if it happens, it may not even happen.
We'll get some courtroom drawings, guys.
Oh yeah,
I get some sketches.
We'll use your pictures to tell a story.
Oh, I have the pictures now.
I have sketches, man. For sure.
Well, Kat, it's your show, so
yep.
Yeah, I think Taviz, do you have anything? We got you. I know you're talking about Boozy, but Dennis didn't ask you the same question that he asked Mel.
Oh no, I'm
now.
not going to no courtroom. No, I'm straight.
What would tear you away from YSL?
What would take me away from YSL is probably, I don't know. I don't even think it would be Diddy for me. It would be a case that would have to, I don't know, maybe Sonia Massey can get me off of that for sure. I'm gonna really start digging deeper into it, even though I have knowledge of it, but digging deeper into it. But that would be a case that's like, once that gets going, it's like YSL might have to be on the back burner. I mean, YSL might be on the back burner by Tuesday, yo. To be honest, because I mean, let's be real.
Low-key kind of hoping
because seriously, like you already got the motion to disqualify both the attorneys. You got the motion for bond and retrial and mistrial with no retrial. You got a whole bunch. I mean, so to be honest, YSL might be over on the 30th. So, you know what I'm saying? So
real quickly, the motion to disqualify DA Love. That's probably if that happens, you know, have to prosecute the case, right? If that happens, who do you think is going to prosecute the case if she gets disqualified?
It'll be Fonnie telling us about song lyrics.
It would probably be Fonnie Willis
herself.
You think so?
Well, she's in charge. She's in charge of the division. She's charge. Miss Love is in charge of that division. So who else would be? Mr. Wooten is on another big case, the Nesto case, and it will be Deja Young. She's also a senior prosecutor. But she's on the Trump case, so it would probably have to be Fonnie Willis and DA Floyd, who's ADA Floyd, who's on the. So they're asking for her to get removed. Do you want Fonnie to come in and prosecute this YSL case?
that'd be hilarious.
Oh my goodness.
I would love to see that. That would be comedy all day.
I would like to see Floyd get better with
bring
his arguments.
Bring her cash with her.
Yes,
cash money.
Yeah, Floyd has some potential though. He really does. He just was nervous. He just really came off like it was a big televised thing. But I really think he could, if he had some energy behind his PowerPoint, I think it would have been easier to digest and watch. 100%. So Floyd might be more organized.
Yeah. Yeah, that may be. Yeah, I don't know. We'll see how this. Be careful what you ask for because you might not get what you want, even with this judge.
True.
People,
Yeah.
I mean, already they took the food away, took the headphones away, took the wardrobes away.
Right.
So
Right.
Thug's gonna have to recycle his outfits, you know. So
The jury's going to be like, what's going on? We've seen that one already.
right,
Mm.
exactly.
Well, there we go. We've got all of the channels, and Ghost has been dropping links to both YouTubes and to X.
Appreciate you, Ghost.
So everyone
Thank you.
say,
Thank you very much.
hey, Drea just
Thank
came
you.
back. You guys show some love for the mods
Thank
in the
you,
chat.
Drea.
They've done a great job keeping you guys
Drea's
connected.
awesome. She's a mod on my channel. She's awesome.
Okay.
She's so awesome.
Yeah, she's dope.
Yeah, and I was hanging out with her on your status hearing stream.
Yeah.
Okay.
And you were
And
so
again,
nice.
there
So you became a member, Kat, on my channel. I appreciate you for doing that.
Yeah, I always
appreciate
try to
it.
become a member on people's channels. I
Yeah.
got to go find Dennis's
dope.
channel, and I don't think I'm a member there. I might have subscribed a long time ago, though.
Okay. We'll see.
But we'll see. Yeah, I'll become a member, and you'll just see a little notification about it. Nick Starro is doing a guest panel with different attorneys and not attorneys. I'm going to hop over there tonight. So one last time, I'm dropping that link in the chat right now. He just does an open panel, you guys. I'm sure it's an open invite.
This was
Nick,
good.
Yeah, thank you for
come on over there.
Yes, thank
honestly,
you, Kat.
I would love
Appreciate
to
it.
do streams that are just panel focused, like something that's meant to be a conversation where we hammer this stuff out. We can do it anytime. You guys all take care. Bye, chat.
All right.
Thank you, guys.